My lord, I have an urgent matter. If your lordship kindly accommodate me tomorrow at 2 p.m.
What matter?
My lord, the matter is a service matter. My lord, the reporting officer gave me an outstanding. Now, ultimately, my lord, the accepting authority has given, they reviewed it, and they have given very good in order to deprive me. In the last occasion, also in 2024, the same thing happened. Your lordship passed an order. In the 2025, also they have started the same.
So why it has to be taken up today only? Why it can't be taken up
Today is
tomorrow?
the interview at 2:30 p.m. my lord.
Today is the,
Interview at 2:30 p.m.
so what will happen
If
if
your
you
lordship protect me, my lord, that is the only.
we'll take it up tomorrow? If you make out a case, we'll stay it.
Follow.
Yes.
Oblige.
Lordship, in item number 2, Lordship, I have filed one affidavit yesterday, Lordship. So that may be requisition.
Item number?
2, Lordship. Lordship has fixed this matter for disposal, Lordship.
All right.
So I have extra copies also, Lordship, only for the purpose of tagging, Lordship. That is.
All right. All right. Yes, yes.
May it please your lordship. I beg to mention item number 9, lordship. With the
Yes.
consent of the other side, lordship, let it be taken after 2 weeks. My senior, there is some medical round on my senior.
Item 9 on the prayer of learned
Lordship, I
counsel.
could respond.
Any objection?
I'm appearing on behalf of Mr. Esner.
On the prayer of learned counsel for the petitioner made with the consent of the other side. Admission hearing of this matter stands adjourned for 3 weeks. List accordingly.
May I please, your lordship? So with the consent of the petitioner, lordship, I beg to mention item number 21, lordship.
Item
On behalf of
number
SS
21.
Roy, lordship, he is out of station, lordship.
Hmm?
Item now 21. If it is not in your lordship, no 3rd of April, lordship.
No, fixing date is not possible. You want time, that is another thing. Because we have already fixed matters on that day. Suddenly, this is already a fixed matter today. So again, you want a fixed date, again, you want a fixed date. That will not. So item 21, you are for the petition.
I'm for the petitioner, my lord, penalty dismissal from service.
Why you can't do it today?
He is out of station.
Who is out of station?
Mrs. SS Roy, lordship.
Out of
Last date
station
it was
what
fixed
happened?
in his presence. Last date was fixed.
You are appearing in this case.
No, lordship, I am not. I am sorry on behalf of.
What to do? A fixed date giving is not possible before Bihu. Then you have to go after
As
this.
per your lordship's convenience.
On the request of learned counsel for the Mr. Das,
Yes.
after Bihu.
Mine.
Hearing of this matter stands adjourned for 3 weeks. List immediately after reopening of the Bihu holidays.
26.
Mr. H.K. Das is present on behalf of the petition.
22nd.
No, that will come immediately after reopening.
Mile.
Obliged.
May it please your lordship. Your lordship, I beg to mention for listing of a writ petition we have filed today, your lordship. Can it be on tomorrow, your lordship?
What is the
The
urgency?
urgency is that your lordship, the petitioners herein, they are temporary workers working for this social welfare. The erstwhile social welfare, now it is Women and Child Development Department. So what the respondent authority, that is the District Commissioner of Borpeta District, what he has done, he has issued a advertisement calling on candidates to fill up the posts that are being held by the petitioners.
What is the last date of submission or application?
That is on 25th, your lordship.
25th, Monday.
Monday, your lordship. Published, your lordship.
Lordship, I beg to mention item number 3, Lordship, with the consent of petitioner, Lordship. The arguing counsel, Mr. P.K. Garude, is not in station, Lordship.
Item number 3.
Yes, Lordship. With the consent of the petitioner, Lordship, kindly adjourn the matter for 2 days.
You are appearing for 1 to 5. Respondents 1 to
Yes,
5.
yes,
You've taken the consent.
yes, Lordship.
No objection. How much time?
2 weeks, Lordship.
On the prayer of learned counsel for the respondent numbers 1 to 5 made with the consent of the other side, admission hearing of these matters stands adjourned for 2 weeks. List accordingly.
May it please your lordship. Lordship, with the consent of other side, I beg to mention item number 12, your lordship. Here we need to file a reply. They file in opposition, your lordship.
You are for whom?
For the petitioner, your lordship.
On the request of learned counsel for the writ petitioner. Admission hearing of these matters stands adjourned for 2 weeks so as to enable him to file rejoinder affidavit.
May I please, your
Oblige, your
lordship, I'd like to mention item number 10 and 11 with the consent of the petitioner side, lordship. I'm making mention for respondent number 4 and 5, lordship. We have to file an affidavit in opposition in item number 11. Both the matters are same and tagged. Your lordship may kindly grant us 2 weeks time, lordship.
On the prayer of learned counsel for the writ petitioners made with the consent of the other side. Admission hearing of these writ petitions stand adjourned for 2 weeks. so as to enable him to file rejoinder affidavit.
Lordship. Yes, Lordship.
May I please, Lordship? Lordship, with consent of the other party, I beg to mention item 22 of the supply list. Lordship, my senior is in bereavement, Lordship, so I prayed
Item?
for the pass of 22 of the supply list.
You are for
20.
whom? You are
From the petitioner, Lordship.
Mr. Ahmed is appearing in this matter. He called me yesterday. Somebody in his family has passed away. Your Lordship, this is the transfer matter. May I pray that it may be taken up on Tuesday, Your Lordship? I have some urgency because the interim.
on the prayer of learned counsel for the petitioner seeking adjournment and taking note of the urgency expressed in this case by Mr. D. Senapati, learned counsel for respond numbers 2 and 3. Admission hearing of this matter stands deferred till that will be 22nd, is it?
25th, Your Lordship.
25th of March 2025. List the matter on 25/3/2025 as a fixed item.
May it please, your Lordship. I beg to mention item number 7 on behalf of respondent number 7 D. Your Lordship. Lordship, with due permission from the.
Item number 7.
7, Lordship. Respondent number 5, Lordship, with due permission, Lordship. He is out. Mr. Sutia is out of station, so 2 weeks times maybe.
I'm for the petitioner.
The learned counsel for the respond number 5/6 adjournment of admission hearing of this case with a request to post the matter again after the Bihu vacation. Since the prayer is not opposed by Mr. A.M. Datta, learned counsel for the petitioner, semi-finals allowed, let the matter be listed accordingly.
Obliged.
May I please, your Lordship?
Yes.
Lordship, item number 8, my lord. My lord, according to the instruction from the petitioner, my lord, I want to withdraw, my lord, this matter.
Your name, please.
R.I. Bhuya on behalf of Annie's mother, Bhuya, my lord.
Mr. Anish Madharvia, learned counsel for the writ petitioner, submits that he has instructions from his client to withdraw this writ petition. The learned counsel for the respondents does not have any objection to the said prayer. In view of the above, this writ petition stands disposed of on withdrawal. Interim order, if any, shall stand vacant.
My lord, I beg to mention item number 20.
Yes.
Senior counsel Mr. Saiwala has been recently engaged as the standing counsel for ASTC. We require 2 weeks time, my lord. And the original service records were called for that has not been received.
So have you informed the petitioner's counsel?
Yes, ma'am.
With the consent of learned counsel for the petitioner, a prayer for adjournment has been made in this case on behalf of the learned standing counsel for the ASTC. In view of the ground cited by the learned counsel, the prayer stands allowed. List after Bihu vacation.
Much.
May I please, your Lordship? Your Lordship, with the consent from the other side, I beg to mention item number 6. Your Lordship, the arguing counsel, Mr. S.P. Roy, is not feeling well.
Feeling
So,
well.
maternity-
As paid for by petitioner's counsel, admission hearing of this matter stands adjourned for 3 weeks.
Obliged, your Lord.
May it please your lordship.
My lord, before my learned friend starts, my lord, this order in respect of which this application seeking a vacation has been filed, this was passed after a hot contest. Therefore, whether your lordship should take up the whole matter or my lord, this stay vacated. Because on principle, my lord, this is not maintainable. Because this order was passed, it's an intra-party order. It's not that it's an ex-party order of which my lord, a vacation has been sought for. I've just pointed out that aspect of the matter.
In fact, I am on the same page. This was what I was about to submit, that on the last occasion, it was decided that the whole matter will be traced out, not the interim. That's why interim or application that IA may not be considered, the whole matter may be considered. That is my prayer.
All right, as you.
We are ready for the hearing.
My lord, hearing some other day.
It was understood, and that is why reason that today matter was fixed, that the whole matter will be heard.
So many matters we come prepared, reaching here, we get to know it should be adjourned.
Mr.
So this is
Chaudhary,
not-
Lordship,
this is not that art shattering a
Mr.
matter.
Chaudhary and Mr. Saikia,
Yes.
you know
Hmm.
how we judges are functioning. You decide what you want to do.
No, but-
You want to
no,
conduct
no,
the
no.
hearing.
No,
Here
it
you-
was understood, it was under understanding on the last occasion, 20th is fixed for final disposal of the matter. I mean, the whole matter will be traced out, lock, stock and barrel. That was the understanding.
My lord, in so many matters with such
As because
understanding,
the-
states takes time. We are
If
told
they one
this
time, that
morning,
is a different
the
story.
Advocate General is
If
not
the
there.
other side wants
The
time, that
Advocate
is a
General
different
not there,
story.
Therefore, matter cannot be
Yeah,
taken
all
up.
right, all right,
If they
So,
want,
in case it is
if
happening
they want
there, it may
adjournment,
now.
that is the story is different.
all right, all right. What is the problem, Mr. Chaudhary?
My problem is, my lord, number one,
Hmm.
if it is for disposal, let a date be fixed. my lord. Let it be taken up tomorrow. I'll do it tomorrow. Tomorrow I'll do it.
Mr. Saika, what is your response?
Yes, tomorrow, let them start because they will take quite substantial time. My response will be on Monday. I'm not available in Guwahati
No
tomorrow,
problem.
but my colleague will be here, or else on Tuesday, Lordship may take up the matter, whole matter.
Or lordship will take it up on Monday.
Tuesday.
Tuesday.
No, my lord,
Is
Tuesday
a
I'm
he-
not there.
Then let it start tomorrow, Lordship. Let it start tomorrow. My colleague will be here, no
No,
problem.
tomorrow is not convenient for the court.
Absolutely, Lordship. Then Monday.
Then Monday, my lord.
All right. Heard Mr. Kane, no, you right, heard Mr. D. Saikya and his Advocate General Assam appearing for the applicant. Also heard Mr. Kane, and his senior counsel appearing for the opposite party lead petitioner. At the outset, Mr. Kane Chaudhary submitted that since that instead of considering the prayer made in the IA, the entire writ petition be taken up for disposal. And therefore, he has sought posting of this matter on some other date for final hearing of the writ petition. Mr. Saikya, learned Advocate General Assam, has agreed to the said proposition but has sought posting of the matter on an early date. In view of the above and as agreed to by learned counsel for both the sides, the writ petition be posted for admission hearing on, what is the date? 24th.
24th.
24th of March 2025 as a fixed item for admission hearing along with this IA, with the understanding that on the next date fixed, the writ petition itself will be taken up for final hearing and disposal.
Highly obliged.
Interim order is there, it stands
Yes.
extended till the next date.
No, it is already, my lord, it's operating. my lord.
Yes.
Yes. Wait, please, your lordship. My lord, this is a matter filed by the Direct Recruit Civil Engineers of Public Works Department. The dispute is essentially with regard to my lord seniority. Now, if your lordship would kindly come to page number 55. এই কিতাপখন আছে নহয়? Page 55, my lord.
Yes.
Now, this is the advertisement which was issued on 19/11/19 for recruitment of my lord, total 156 number of assistant engineer. Pursuant to this selection process, which was started in 2019, we were recruited, my lord. And at page 61, is our appointment order. Kindly mark the date. It's very important in this case, 21/9/2022.
So you are for the direct recruit.
We are direct.
Yes.
Now, my lord will kindly come to page 76. On recommendation of, this is my lord 6/01/23. On the recommendation of selection board in its meeting held on 7/12/22 and in pursuance of department's notification dated so and so, subject to reservation without any notice, and also without assigning any reason thereof, and without prejudice to their inter se seniority, Governor of Assam in public interest is pleased to promote the following officers working in the rank of deputy junior engineer civil under so-and-so in the pay scale so-and-so, 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 other as admissible under the rules, and post them against the existing vacancies shown below. So kindly see, my lord, present posting so-and-so, so they have been given the so-and-so posting. So, my lord, 6/1/23 is the date on which private respondents number 3298 were promoted from junior engineer. Date lordships will get at 79, my lord. 6/1/23. Now, what the department did, my lord, they have drawn out the inter-seat seniority list of assistant engineer in the public works department, which is at page 155. It was published on 17/9/24. Lord, serial number 82, serial number 176 at page 157 to 161 are respondents number 3298. And
Serial numbers?
Serial number 81 to 176.
Private respondents.
Yes. They are 3298. And the relevant page is 157 to 161. And petitioners are at serial number 177 to 426 at page 161 to 168.
Read petitioners, please give the number again.
Petitioners, my lord, serial 177 to 426 at page 161 to 168.
Yes.
My lord, assailing this, we filed a writ petition which was disposed of on 16/9/24, which your lordships will get at page 121. And the relevant portion, lordships will get at page 152.
Yes.
I have considered the submission made by the learned counsel for the parties and have also gone through the materials available on record. After examining the scheme of the rules of 1978, more particularly the provisions of Rule 11.4 as well as Rule so-and-so, read in the light of the observation made by the Honorable Supreme Court in so-and-so and so-and-so, I am of the view that petitioners have made out a strong prima facie case in their favor. However, since question of fixation of inter-seat seniority is a matter which is primarily required to be examined by the departmental authority, and considering the fact that keeping the writ petition pending before this court with an interim order operating in the case might prejudicially affect not only the interest of the departmental candidates, but also department itself, if promotional post in the rank of assistant executive is there remain vacant for a long period. With the consent of learned counsel for both the sides, this writ petition is being disposed of at the motion stage by granting 2 weeks time from today to the writ petitioner to submit a first representation before the Commissioner and Secretary Government of Assam, PW, by enclosing a certified copy of this order, ventilating their grievances in the matter. If such a representation is submitted within 2 weeks from today, the grievance of the petitioners be looked into and representation be disposed of by reasoned order. Whatever be the outcome of the process, the same should be communicated to the writ petitioners in writing. Until such time the aforesaid exercise is carried out and completed, no further promotion from the joint cadre of assistant engineer in PWD based on improved gradation list shall be processed. So, my lord, the most important part in this order is your lordships recorded a prima facie satisfaction that the provisional gradation list which was put to challenge was prima facie not correct. Now, pursuant to this order, my lord, they have passed the impugn order at page 183. एसी तो सुनो ना नहीं एसी तो सुनो ना वो कारण whereas PWD wide notification dated, I'm sorry,
Yes, yes.
21/9/22 appointed 255 number of assistant engineer under the joint cadre of PWD and PWD department, NH department. Whereas the PWD road held a selection board meeting on 7/12/22 for promotion of junior engineer to the rank of assistant engineer under the joint cadre of PWD and PWD Building and National Highway Department. Accordingly, 106 number of junior engineers were recommended by the selection board for the existing vacancies of the year 2022. Further, on the approval of the Honorable Chief Minister, PWD on 16/12/22, a select list of 106 number of officers for promotion to the rank of assistant engineer has been issued by PWDR's notification dated so and so. Subsequently, on the approval of the Honorable Chief Minister on 4/1/23, Lord, you will kindly mark this date which will have great relevance. 4/1/23. The PWD wide notification dated 6/1/23 has promoted 106 number of junior engineers to the rank of assistant engineer under the joint cadre of PWDR and PWD Building and National Highway Department under Rule 11(4)A and B of the Assam Engineering PWD Service Rule as amended. And whereas Assam Diploma Engineers Service Association by their letter dated 17/3/23 has requested the PWDR to consider the seniority in the gradation list as per provisions of Rule 22(3) of the Assam Engineering PWD so and so. In respect of 106 number of assistant engineer promoted by notification dated so and so, considering that all the procedure for promotion were completed in the year 2022. And whereas the PWDR wide its endorsement dated 26/4/23 in e-file number so and so has sought for the views of personnel department regarding seniority of the said 106 number of promoted assistant engineer. Accordingly, the personnel department wide its endorsement dated 26/5/23 in e-file number has requested PWDR to refer to Rule 22(3) of the Assam Engineering PWD Service Rule, which states a member appointed by promotion against a vacancy occurring in a year shall be senior to member appointed by the direct recruitment of that year. Further opine that 106 number of junior engineers who were promoted against vacancy of the year 2002 and notified in the year 2023 will be senior to those direct recruits of the year of 22. My lord, my humble understanding is
So this is being done in deference to the provision of Rule 22(3).
3.
So the core issue is what is the interpretation of 22(3).
Correct. Along with some associated rules, my lord. Now, my lord, the sum and substance of this impugn order dated 29/1/25 is they themselves admit that promotion process was initiated in 22 and it culminated in 2023. Why that yardstick is not applied to us, though it is not relevant. I'll come place Supreme Court decisions. why they do not take the position that our recruitment started in 2019, it culminated in 22. So, my lord, Supreme Court says that when the advertisement was issued, when appointment was issued, these are not relevant. What is relevant is when you become member of the service. That's the crux. Now let us, my lord, test the view of the Personnel and Judicial Department, which has been echoed by the Public Works Department. Now please have the rules, my lord. I'll place few rules. And my lord, as far as facts are concerned, these are the facts.
It's in a narrow campus.
Very narrow. It's all depends upon. Well, I'll place few rules, my lord. First, my lord will kindly come to Rule 2J at page 4.
Page 4.
Excellent. My lord, I'll come from 1 second.
John,
Just for 1 minute.
I'm like, no.
Go, please.
Please start.
No, please.
2J, my lord. Year means a calendar year. At page 4, 2J.
Yes. Yes.
Then my lord will kindly come to 6(1)(a).
Mm. 6(1)(a).
A. It relates to direct recruitment, my lord. When direct recruitments are made, how it operates. Before the end of each year, the government shall make an assessment regarding likely number of vacancies to be filled up by direct recruitment during the next year. So, my lord, this advertisement was issued in the year 2019. Now, if we go by the letter and spirit of Rule 6(1)(a), the vacancy which has occurred during 2019 and anticipated vacancies of 2020 will form the basis. Am I clear, my lord? Because it says, before the end of each year, government shall make an assessment regarding likely number of vacancies to be filled up by direct recruitment during the next year. That means in 31/12/2019, the assessment will be made. What is the vacancy during that year of 2019, calendar year, and calendar year of 2020. So that those posts would be advertised for. Existing would be of 2019 and anticipated would be of 2020. Now similarly, if your lordship kindly comes to Rule 13, same is the provision for Rule 13 also, my lord. Rule 13(1). Before the end of each year, the government shall make an assessment of the likely number of vacancies to be filled up by promotion in the next year in each council. So, my lord, in case of promotion also, when the process was started in the year 2022, so they took note of the vacancies which was existing in 22 and those likely to anticipated vacancies likely to occur in 2023. So we were recruited against vacancies of the year 22 and my learned friends clients were promoted against vacancies of 2022 and 2023. Now please come to Rule 22(3).
Yes.
A member appointed by promotion against a vacancy occurring in a year. Kindly mark this, my lord. A member appointed by promotion against a vacancy occurring in a year shall be senior to the member appointed by direct recruitment of that year. Yes, if the vacancy occurs in the same year and if
So the
direct
core question is, when did these vacancies arise?
No, my lord.
Against
No,
which
my lord.
the
I thought that was the correct position. That is not. Going through the Supreme Court judgment, now I find In such type of controversies, Supreme Court says only way to find, determine seniority is based on the test of when you join the cadre. And more particularly here in these rules, my lord, this calendar year has been defined to mean a calendar year. There is no dispute that we were appointed in September 22 and their appointment was approved by the competent authority, that is the minister, on 4/1, next calendar year. Now that also I'll place, my lord. So my lord, going by literal meaning, if we are to give a literal meaning to Rule 22(3), it clearly says that the vacancies must be of the same year, and if recruitment takes place, it is not. I have clearly shown, my lord, these vacancies can be of the same year. These are vacancies of different years. Now, even, my lord, that was my understanding also, but having gone through some of the judgments, I find no. Supreme Court has said these are not safe. Only best criteria is to find out when you became the member of service. Now, my lord, regarding this appointment part, that I'll place, my lord. Yes. If your lordship should kindly come to Rule 12.
Yes.
No, I'm sorry, my lord. Once again. Approval to put like appointment. One second. Excellent, excellent. Yes. Kindly come to Rule 13(6), my lord. It lays down the general procedure for promotion. Rule 13(6).
Yes.
My lord, selection board has published a list and there is a requirement of approving the list. The appointing authority shall consider the select list prepared by the board along with character, role and personal files of the employees and approve the list unless it considers any necessary. If appointing authority considers it necessary to make any change in the list received from the board, he shall inform the board of the changes proposed, and after taking into account comments, if any, board may approve the list finally with such modification as it may, in his opinion, just and proper. So this approval came on, my lord, 4/1/2023 in the next calendar, so far as the private respondents are concerned. So, my lord, it is in this scenario, your lordships will have to take a call whether the direct recruits were recruited in 2022 should be ranked senior, or the promotees were promoted in the year 2023 would rank senior, as has been done by the department.
The rules are not under challenge.
No, no. Now, my lord, I'll place some case law.
Yes.
My lord, I'll place some case laws on the point, my lord.
Yes.
The other day, my learned friend was. Just give me 1 minute time, my lord. My lord, I'll go chronologically, my lord. First, if your lordships will have that 1977 1 SCC 308.
Yes. The book list, sir.
N.K. Chauhan. I've given the book copies. 1977 1 SCC 308.
Yes.
Para 40.
Yes, please.
This brief and quick survey of decided cases and submission considered by us in the judicial crucible, till the following conclusion. Leaving aside the question of confirmation in service, which in Gujarat setup leaves our controversy untouched. Please come to see, Milord. Seniority normally is measured by length of continuous officiation in service. The actual is easily acceptable as legal. This does not preclude a different prescription constitutionally, tests being dissatisfied. So, my lord, the broad preponderance of the Honorable Supreme Court on, my lord, seniority is, it is always by continuous officiation. In other words, who has come to the cadre earlier in point of time. Then next judgment, my lord, is
But
19
Mr. Chaudhary,
Yes.
see,
This is a broad proposition.
broad provision.
Broad proposition.
There, this kind
No,
of.
no, I'm coming to state cases. Well, that's the, well, I have read the judgment in seriatim as I have found out. Then, my lord, 1991, Supply 1 SCC 334. I've given that. একেলগে দি নিদিয়ে একটা। ওটা কিটা দি দিও। Milord will kindly come to paragraph 12. It is also a almost identical fact situation, Milord,
Yes.
where direct recruits and the promotees were fighting for seniority. Para 12. In the instant case, the promotee respondents 6 to 23 were not born in the cadre of assistant engineer in Bihar Engineering Service 2 at the time when respondents number 1 to 5 were directly recruited to the post of assistant engineer, and as such, they cannot be given seniority in service of assistant engineer over respondents 1 to 5. It is well settled that no person can be promoted with retrospective effect from a date when he was not born in the cadre so as to adversely affect others. It is well settled by several decisions of this court that amongst the members of the same grade, seniority is reckoned from the date of their entry, initial entry into the service. So these are the subtle positions.
No, absolutely. There's no, there can't
Yes.
be any quarrel with that.
Yes.
Only question is when there is a rule like this and that rule is not under challenge,
Yes.
then what is the view the court is required to
Yes,
take?
yes.
That is the only
Yes.
issue. Otherwise, broad proposition,
Yes.
there cannot be any quarrel.
Yes.
Whoever is born in the cadre earlier will be
You'll
senior.
be senior.
Absolutely. But it seems, subject to what you say and what their stand is, Rule 22(3) seeks to put a spanner in this normal progression.
No, my lord. My learned friend the other day said that this Assam rule is exception. I have brought the same rule, my lord. Say, I am placing it one by one. Please come to 1994 Supplementary 1 SSC 276. Bhera.
Yes.
Bheram Sharma. Para 5. This court has examined the question of fixation of seniority inter se between officers appointed from different sources, that is by promotion and by process of direct recruitment. It is almost settled that while determining inter se seniority amongst officers recruited from different sources or between officers appointed by the same process at different time, the date of entering the service is relevant. A person who enters the service first shall rank senior unless there is some rule providing otherwise, which can be held to be consistent with Article 14 and 16. Next, Milord will kindly take 1998 4 SCC 456, 2 paragraphs, para 24 and 34. Jagadish Chandra Patnaik.
1998.
1998 4 SCC 456.
Yes, please. Which paragraph you want to rely on?
Yes. Please come to para 24, my lord, which is perimetria provision, that is rule 26 in the rule which was under challenge before the Supreme Court. Rule 26 at para 24, page 464.
Yes.
Rule 26, which we are really concerned in the present case, is the rule of seniority. It would be appropriate to extract the said rule 26 in extension. When officers are recruited by promotion and by direct recruitment during the same year, the promoted officers shall be considered senior to the officers directly recruited, irrespective of the date of their joining the appointment. Well, this line, irrespective of date of joining an appointment, is not there in the Assam rules. Yet Supreme Court says no. It is the date of entry that will matter. I'm reading it again, my lord. When officers are recruited by promotion and any direct recruitment during the same year, the promoted officers shall be considered senior to the officers directly recruited, irrespective of the dates of joining the appointment. Now, this line is not there in our. For a moment, if your lordship kindly takes our rule, my lord, for a moment.
Mr. Chaudhary, there is a little difference between 26 and the rule 22.3.
No, my lord. There is
No, I'll tell
one
you- I'll tell
difference
you.
is okay.
22.3 hinges on the basic premise of the
Vacancy.
year in which the vacancies arose.
Yes.
And this 26.1
Ah,
takes note of who has joined earlier in the service. Is
Oh,
that
not-
correct?
correct. Yes, correct. There it is vacancy, here it is recruitment. But despite that, my lord, there's an added rider here, irrespective of their dates of joining the appointment. My lord, if we go by that vacancy part, we are through, my lord. There is no difficulty because vacancy is not of the same year. Vacancies are of different year.
Then let's
So
focus
why
on
I'm
that.
saying so, my lord, I can't make a wrong submission.
Correct, correct.
The next judgment which I'll be placing where Supreme Court says we are not supposed to take note of that. That's why. Now, my lord, let us come to para 34 of this judgment.
The 1998.
Yes.
Yes.
3 contentions were taken note of. 2 contentions were rejected. All the contentions were rejected, my lord. Please come to para 34.
Yes, please.
The only other contention which requires consideration is one raised by Sri Raju Ramachandran, Laneth Senior Counsel appearing for the interveners to the effect that expression recruitment and appointment have 2 different concepts in service jurisprudence, and therefore when Rule 26 uses the expression recruited, it must be a stage either earlier to the issuance of the appointment letter and logically should mean when the selection process started and what appears to the intendment of the rule makers in Rule 26. We are, however, not persuaded to accept this contention, since under the scheme of the rule, a person can be said to be recruited into service only on being appointed to the rank of assistant engineer. Kindly mark this. We are, however, not persuaded to accept this contention, since under the scheme of the rules, a person can be said to be recruited into service only on being appointed to the said rank. Then, my lord, other aspects were considered. Then please come to placitum E and F.
Yes.
But both in the cases of direct recruit as well as the case of promotees, the final selection vests with the state government under Rule 15 and 18 respectively. And until such final selection is made, appropriate orders passed thereon, no person can be said to have been recruited to the service. Therefore, I said, my lord, this date 4/1/23 is very, very important. I'm reading it once again, my lord. But both in the case of direct recruitment as well as in the case of promotee, final selection vests to the state government under, in our case, my lord, Rule 13(6). In their case, and ours was definitely in 2022. And until such final selection is made and appropriate orders are passed thereon, no person can be said to have been recruited to the service. So they were recruited to service only when, my lord, their selection was approved by the minister concerned under the rules of executive business, following which on 6/1/23, their appointment orders were. So therefore, they were recruited in 23.
Okay, I'm just pausing you for a moment, just for the sake of clarity in understanding your case, subject to what they said. You have mounted the challenge primarily on two premises. The first, if I've understood correctly, is that these vacancies against which the promotees have been adjusted cannot be said to have arisen in
In the same year.
in the same year, that is 2022. And therefore, even if Rule 22(3) is to be applied,
Then also not.
then also in the facts of the case, they cannot rank senior by operation of Rule 22(3)
Itself.
This is number one.
Yes, yes.
Number two could be an alternative argument.
Yes.
Please clarify if it is your argument that even if the vacancies arose on the same year,
Yes.
even then, this regardless of what 22(3) says,
Yes.
seniority has to be determined with effect from the date of joining.
Entry.
Whoever entered the service earlier,
Yes.
so to that extent, the court should ignore the Rule
Yes.
22(3).
Yes.
But that argument is based on the edifice that there is no challenge to Rule 22(3).
Yes, of course, my lord. And I'm so grateful to your lordships for, my lord, articulating my views, my lord. Now, in this case, Rule 26 itself was interpreted. Now, please come to Placitum F.
Placitum F.
Yes. In this view of the matter, the only appropriate and logical construction that can be made of Rule 26 is the date of the order under which a persons are appointed to the post of assistant engineer is the crucial date for determination of seniority under the said rule. Raju Ramachandran's contention therefore cannot be sustained. So this is an ultimate nail in the coffin, madam.
But this is on the interpretation of Rule 26, which is, you agree that
No,
there is
madam,
slight
yes,
difference.
of course. There here it was a case of when recruited, and ours is a case when the vacancy arose. But in any case, my lord, a perimeter provision, my lord, whether it is vacancy or it is recruited, end of the matter, court was giving an interpretation of Rule 26. Now, my lord, next judgment is, this is where Supreme Court says, my lord, that these are not relevant. And 2020, 5 SCC 689. Megha Chandra Singh versus Ningam Siro. K. Megha Chandra Singh, 2020, 5 SCC 689. My lord will kindly come to para 28. Here I'll rely on 3 paragraphs.
Yes.
Before proceeding to deal with the contention of the appellant's counsel vis-a-vis the judgment in N.R. Parmar, it is necessary to observe that law is fairly well settled in a series of cases that a person is disentitled to claim seniority from the date when he was not born in the service. For example, in Jagadit Chandra Patnaik, the judgment which I read, the court considered the question whether year in which the vacancy accrues can have any bearing for the purpose of determining seniority, irrespective of the fact when the person is actually recruited. Now, this is the answer. The court observed that there could be time lag between the year when the vacancy accrues and year when the final recruitment is made. Referring to the word recruited occurring in Orissa Service Engineering Rule 1941, the Supreme Court held in Jagadish Chandra Patnaik that persons cannot be said to have been recruited to service only on the basis of initiation of the process of recruitment, but is born in the post only when formal appointment order is issued. The above ratio in Jagadish Chandra Patnaik is followed by this court in several subsequent cases. It would, however, be appropriate to make a specific reference, considering the seniority dispute in reference to Arunachal Pradesh, rules, which are in perimetry to the MPS rules of 65. Having regard to the similar provisions, the court approved the view that seniority is to be reckoned not from the date when the vacancy arose, but from when the date on his appointment is made to the post. The court particularly held that retrospective seniority should not be granted from a day when an employee is not even born in the cadre, so as to adversely impact those who were validly appointed in the meantime. I think, my lord, this answers your lordship's concern also, this paragraph, para 28, because this line, my lord, placitum F. For example, in Jagadish Chandra Patnaik, the court considered the question whether the year in which, there it was year, our it is vacancy, which vacancy accrues have any bearing for the purpose of determining seniority, irrespective of the fact when the person is actually recruited. So, my lord, the Rule 26 in Jagadish Chandra Patnaik was construed in a manner that since it did not took note of the when it was recruited, therefore the rule has to be interpreted in this manner. Then ultimately what is decisive is when you are recruited. Am I clear to your lordship's mind? Para 30. We may also benefit by referring to the judgment in state of UP versus so and so. This judgment is significant since this is rendered after N.R. Parmar. Here the court approved the ratio in Pawan Pratap Singh and Rivam Singh and concurred with the view that seniority should not be reckoned retrospectively unless it is so expressly provided by the relevant service rule. The Supreme Court held that seniority cannot be given to an employee who is yet to born in the cadre, and by doing so, it may adversely affect the employees who have already been appointed validly in the meantime. The law so declared in Ashok Kumar Srivastava being appealing to us is profitably extracted as follows. Please come to that quoted portion, my lord, para 45. Inter se seniority in a particular service has to be determined as per service rule. Date of entry in a particular service or date of substantive appointment is the safest criteria for fixing seniority inter se between one officer or the other, or between one group of officers and others recruited from different sources.
Mr. Chaudhary, I have understood your argument.
yes.
These are prima facie attractive.
Yes.
But I must point out to you,
Yes.
if your argument is to be accepted,
Yes.
then the court will require to read down 22(3),
Yes.
saying that whatever the interpretation,
Yes.
it cannot have a unseating effect of people born earlier.
No, my lord.
But the problem
For
is,
that-
I am asking
for-
again,
for
and again,
that-
this rule is
No,
not
my
under
lord, no,
challenge.
For that, my first submission is there, my lord. This is my alternative argument. My first submission is that vacancy that admittedly is a vacancy of the year 2019.
All right. So what I'm
That is why I did not put to challenge below the rules.
correct. So what I'm pointing it out to you, is
Yes,
that
yes,
prima facie your argument is attractive.
yes,
But if the second limb of argument is to be accepted by the court,
yes.
then it would at least require reading down of the rules. Because these are rules framed under Article 309.
309.
Rules have to be read down.
Yes.
The High Court cannot ignore. Supreme Court has powers under 141.
Certainly, my lord.
High Court cannot ignore. So if the High Court cannot ignore,
No, my lord, if your lordship would kindly consider, in Jagadish Chandra Patnaik also rule was not challenged. And it's not that Supreme Court was
correct,
exercised power under 142. It was not an exercise of power under 142. It was a power which was exercised under 136.
anyway, I'm just putting it to you.
Yes, yes.
Because these are all legal issues.
Yes, yes.
And the more deliberation is there, there will be more clarity.
Yes.
As a judge, one would like to
I
write
think,
a
my lord,
judgment.
my respectful submission would be going by section 13(6), which requires that selection to be approved by the government or by the appointing authority, which is 4(1)23. If any legitimacy is to be given, it can be given only with respect to 4(1)23 and subsequently 6(1)23.
That is correct. That is, if you had a rule like Rule 26, recruitment, the date of recruitment, then the argument will fit into.
Absolutely fine.
But here the date of recruitment is totally irrelevant for the Rule
No,
22.
here it is when the vacancy.
Correct.
Yes.
So therefore, the court, while examining
Look,
the arguments,
my predicament was, having gone through this Megha Chandra Singh I thought it will be incorrect on my part to advance an argument.
No, that's correct. See,
Yes.
what I'm hinting at
Yes.
is, please apply your mind, and because whatever you say and whatever Mr. Kaur and Mr. Nayak says, ultimately that will shape up the
Yes.
outcome of the proceeding, right? So at the moment, the court is interacting with you, so I have to point out what is coming through and you may have a good answer, that answer may be acceptable, not, I don't know. But what I am pinpointedly putting at you is that the rules have a language which is unambiguous language, says that between the two, whenever vacancies arise in a particular year, the promotees will be senior.
Yes.
So that means only criteria is the vacancy should arise in a particular year.
Same year.
And if that happens, then there is no scope to take a different view. The rules are very clear. Now, obviously, the first question, as you have raised, will be that when did this vacancy arise against which the promotees, that we'll ask them and they will have to satisfy. On that count, if they cannot show, then we'll have to go by what is available on record and take a view. In that case, this second parameter may not be gone into.
Yes.
But supposing it is pointed out that the effectively, because they are yet to make their submission,
Correct.
the vacancies arose in the same year. But the process got delayed because of administrative reasons. Then the court will have to look at the impact of the rules on that. And if in that case, the court will have to consider these principles and harmonize it, that normally in service jurisprudence, it is a salutary principle that whoever is born in the cadre first in point of time will have to be given seniority.
Yes.
There is no
Or
quarrel with
else,
that.
my lord, we'll be giving retrospective promotion.
Correct. But the problem here is there is a set of rules made under 309 which comes in the way of this interpretation.
But my lord,
And
in
unless the
Megha
rules-
Chandra Singh,
Hmm.
situation was more or less same. There was no such rule. Megha Chandra Singh.
Mr. Chaudhary, Supreme Court. So we have to remain confined to Article 226.
Anyway, my lord,
You think about
okay,
it.
I can, what has fallen from your lordship, I'll definitely take note.
These
of.
are
If
these are
necessary-
very technical issues. But
Yes.
then the point is, the court will have to consider all these aspects
Yes.
before writing a
My
judgment.
lord, regarding my first point also, it is the government, more than private respondent, it is the government who will have to satisfy when the vacancies are. Yes.
Vacancies, if they can't show the vacancy arose in the same year,
Yes.
then rest of your arguments need not be gone into.
Written, yes. That's why I said, my lord, I had to make this argument only because of the Megha Chandra Singh, where it says when vacancy arose is immaterial.
No, that I followed, that is correct. But Megha Chandra Singh did not consider a rule like Rule 22(3), which is proposing the contra theory.
So in some of the judgments, Supreme Court has said, unless service will provide otherwise. One
Yes,
of the judgments.
it has been said.
Yes,
So I have
Like that.
marked that.
I agree, madam.
See, the idea is to come up with the correct decision as
Yes,
to the
yes.
extent possible. Therefore, the assistance, able assistance on your part.
Yes.
So please respond to it in
Yes,
whatever
I'll do
manner
that,
you
madam.
think.
That my learned, I have a matter in court number 1, madam.
Yes, please.
Yes, ma'am. Well, I'll just rephrase the dates, my lord, which may be 11 for your lordships, my lord. Even for the court, please. Instead of taking notes, you have marked the dates, my lord.
You are always ahead of your time.
So good practice. I always say that good things has to be learned from me, not the bad things. I've got a lot of bad things also. I always advise my senior that good things you learn from me.
Is
discipline
this
you-
list contain a list of those bad things also? No.
No.
Okay,
This
then
is-
we'll
this is
confine,
just for the convenience
we'll
of the.
confine only to the good
Yes,
things. Yes.
Now, your lordship will see in this list, my lord, the first date is 19/11/2019.
Hmm.
That is the day when the petitioner's advertisement for 156 post of assistant engineer were issued.
Just pause for a minute.
Yes.
We'll ask it to the APSC in the government. The advertisement issued by APSC,
Yes, ma'am.
is it based on anticipated vacancies or existing vacancies?
Vacancies of 2019.
Correct.
Yes, existing.
Existing vacancies.
Yes.
Now, the writ petitioners were considered against vacancies arising in the year 2019,
19.
correct?
Yes,
And the promotees, that is your clients,
yes,
they were considered against vacancies arising in 2022.
22.
So what is the dispute here? The rule-
Yeah, unlike in our case where the rule says that vacancies of 2022, in case of direct recruit, that is vacancy of when it arose is irrelevant. The rule doesn't there for direct recruits. It is only in case of promotees the vacancy is relevant. In case of direct recruit, it is the date of appointment because they were born in the cadre only on.
No, Mr. Kaur.
Yes, yes.
Just have a look at the
Yes,
rules,
yes.
22(3) again.
Yes.
Your whole case, whole
Yes,
claim
yes,
is
yes.
based on 22(3), is it
Yes,
not?
yes.
So let us see what 22. We are on seniority.
Yes,
Who will be senior to him?
yes,
There's nothing to do with
Yes.
whose appointment is valid, invalid. There's
yes,
nothing
yes.
to do.
No. Your lordship will see
22(3), what does it say?
a member appointed by promotion against a vacancy occurring in a year shall be senior to a member appointed by direct recruitment of that year. Because they were not born in the cadre prior to 2022. This whole phrase, I'll come to those Supreme Court, I'll basically rely on this submission. This has been clear. Unless you born in a cadre.
So you are saying that if the vacancies against which the promotees were appointed
Yes,
coincides with the year of appointment of the direct recruits,
Yes.
regardless of when their vacancies are,
yes,
then
I'll be senior.
you'll be senior. Now, you are saying that
Mm.
the direct recruits might have been appointed against vacancies of 2019,
Yes, sir.
but their appointments took place in 2022.
Yeah, and confirmation took later on, but I am not going on that confirmation,
confirmation is
date
not
of
there.
appointment, temporary appointment.
But the vacancies against which your clients were appointed, promoted,
Yes,
might have happened in 2000, the promotion might have been in 23.
yes.
But those vacancies are
Of 2020. And that it was, when the matter was placed before the selection board, DPC, it was clearly stated that these are vacancies of 2022. I'll come to those pleadings. And it is the existing vacancies of 2022. These are clear from the affidavit of the government and the record. So I'll place that, my lord, it's on a very narrow. So your lordship will kindly just give a look into these dates because ultimately your lordship has to refer to these dates. So, my lord, 2019, the first date is of the advertisement for 156 posts.
Yes.
Then come, my lord, 6/5/2020, this addendum was issued by the APSC. Initially, it was 156. Then, my lord, subsequently 104 posts were included. I have not forgot to mention this 104. In the addendum, 104 posts more were added. So 156 plus 104. Then, my lord, comes 27/6/2022, selection board meeting for 83 numbers of to the cadre of assistant. This is in a promotees who were already, their meeting was held in 27/6/2022. We are not concerned in this case. Earlier, when your lordship passed a blanket order holding the promotion of everyone installed, they were also affected. But now they have said that, no, we are not against this 27/6/2022 cadres. We are only in case of this private respondent who are before your lordship. Then your lordship will find this is 21/9/2022 is the date when the direct recruit, the petitioners were appointed then. Then, my lord, on 7/12/22, this is the date which is relevant for us. On 7/12/2022, the PWD held a selection board meeting. So and 106 numbers were recommended to the Senate for the existing vacancies of the year of 2022. So the selection board meeting took place on 7/12/2022. Then 16/12/22, the Honorable Chief Minister, who is the Minister of PWD, approved the select list. Then, my lord, on 4/1/2000, then select list was published on 17/12/2022, which is valid for 12 months from the date of approval by the selection board. (17/12/2022), the select list was published. 4/1/2022 is the Honorable Chief Minister approved the select list, and 6/1/2022, my lord, the notification was issued promoting 106 numbers of the persons whom I represent. My lord, this representation was filed on 17/3/26/4. I have given chronologically. Ultimately, my lord, your lordship will find in the next page, after all the orders, the 16/9/2024, your lordship has passed the order in the page number 2. The others, all the dates are in seeking views of the different departments. 16/9/2022, your lordship directed to dispose of the representation of the direct recruits, and until such time, no further promotion from the point of joint cadet. Then, my lord, after your lordship's order, the final gradation list was published on 17/9/2024. Then against this, my lord, they filed a representation. Then they were heard in person, my lord, your lordship will find on 29/11/2004 in the next page at page 3, they were heard in person. Then the page 183, that is 29/1/2025, the PWD by speaking author dispose of their representation. And the 31/1/2025, my lord, after this represented, the Honorable Cabinet allowed one-time relaxation of the qualifying services for promotion from 5 years to 2 years. Earlier from assistant engineer to assistant executive engineer, in terms of the rule, qualifying services 5 years, they have said that it is 2 years. Then 17/2/2020.
That is not a subject.
No, that is not a subject.
That applies.
Now
to
your
22.
lordship will see rule 22(3). The first judgment, my lord, which my learned friends have relied, my lord, your lordship will see that judgment.
Yes.
Before your lordship go, let me show you from the pleadings of the government, my lord. Just a moment. Your lordship will kindly look in the affidavit in opposition filed by the respondent number 2, page number 272. Page number 272, paragraph 16. Only 2 paragraphs are relevant, my lord, your lordship will say. Your lordship got it?
Yes, please.
That as regards the statement made in paragraph 23 of the writ petition, the deponent begs to deny the same as incorrect. The 106 numbers of vacancies in the cadre of assistant engineers civil PWD, that is we, my lord, occurred in the first half of the calendar year 2022. Due to the
Just a
huge,
minute, just a minute. Where is this 272?
my lord, it's,
Is in which writ petition?
my lord, there's only one writ petition.
Acha, now. The call for the. All right.
272, my lord. Paragraph 16.
Yes.
That as regards the statement made in paragraph
This is
20.
your copy.
Now, we have an unmarked copy. Your lordship can look into an unmarked copy.
When was this filed? This affidavit? Yeah, you have received copy, Mr. Decker?
Paragraph 16, man.
1 minute.
This affidavit is filed by the respondent number 2, my lord, AIO. If your lordships looks at paragraph number 16.
Yes.
That as regard to the statements made in paragraph 23 of the writ petition, the deponent begs to deny the same as incorrect. The 106 numbers of vacancies in the cadre of assistant engineer civil PWD occurred in the first half of the calendar year 2022. Due to huge number of projects at hand which had to be implemented in war-footing manner, the government of Assam PWD decided to fill up those vacancies in the cadre of assistant engineer civil by way of promotion from the cadre of joint engineer civil, junior engineer civil PWD in the interest of work. Hence, a DPC was convened on 7/12/2022 and the recommendation of the DPC was accepted by the government, and accordingly, select list was issued on 17/12/2022. However, following some administrative formalities, the promotion notification could only be issued on 6/1/2023. Further, it is pertinent to mention it here that no illegality was done in promoting those 106 numbers of assistant engineer, as the department was in need of assistant engineers for implementation of huge numbers of projects undertaken by the government. Further, the assistant engineers were promoted against the vacancies of the year 2022. Then your lordship will see paragraph 18. Next paragraph, my lord, paragraph 18. As regard to the statement made in paragraph number 25 and 26 of the writ petition, the deponent begs to state that the respondents were promoted against the clear vacancies of the year 2022, and hence they have been placed above directly recruited assistant engineers of the year 2022 as per Rule 2023 of the Assam Engineering PWD Service Rule 1978 as amended. Now your lordship will see paragraph number 21.
Yes.
that as regard to the statement made in paragraph number 29 of the writ petition, the deponent begs to submit that the date or year in which the vacancies are occurred in the matter of the petitioners being direct equals may not have any significance under the provisions of Rule 22(3) of the Assam Engineering PWD Service Rules. Then your lordship will see paragraph number 23. As regards to the statement made in paragraph number 31 of the writ petition, the deponent begs to reiterate the statements made in paragraph 15 of the instant affidavit in opposition. Further, more than 200 numbers of posts in the cadre of Assistant Executive Engineer Civil PWD are currently lying vacant. As such, in the interest of public service and to fill the vacant posts to accelerate the implementation of huge number of projects undertaken by the government, the Honorable Cabinet in its meeting held on 31/2/25 has granted one-time relaxation of Rule 12(3)A and Rule 3(A)(2) of the Assam Engineering Rules 1978 as amended. Now your lordship will see the annexure at page 277. The first annexure, my lord, 277. My lord, your lordship will find that annexure 1 at page 277 is the minutes of the selection board meeting for selection of officers of PWD for promotion to the rank of Assistant Engineer Civil from Junior Engineer Civil held on 7/12/2022 at 11 AM in the office chamber of the Honorable Chairman, Assam Public Service Commission. Then the members present, my lord, chairman, members, everything is given. Then all the rules are discussed. Then your lordship will look at 5A. 5A. Of officers recommended for promotion against the 106 existing vacancies of the year 2022. Then your lordship will find that list is given. I have given another interpretation of the list. I will take your lordship to that.
These candidates in this list are your clients.
Yes, my lord. Now, this list is there, my lord, and your lordship will find that 282. 282 is the all the members have, and including the chairman of the APC has put their signature. Now your lordship will look at 283. This was 283 was the endorsement, my lord. Endorsement of the personnel department as page 283. Accordingly, the 106 numbers of junior engineers who were promoted against vacancies of the year 22 and notified in that year 2022 will be senior to those recruits of the year 2022 as per rules. Then your lordship will look at page 284. Page 284 is the note of the judicial department, my lord, who has also said that we are senior today because the vacancy occurred in that particular year.
Yes.
Then your lordship will look at the after the
So
representation.
all the 106 junior engineers promoted as assistant, they are parties in the writ petition?
Yes, my lord.
All of them.
All of them. Or no, or not. Huh? Some have retired, my lord. So they are not people. People who have
Some
retired.
has retired, some has died.
Yes. So they are not before your lordship. So next page, your lordship will find 285. After the representation, the personal view department view was once again sought for, and the personal department reiterated its earlier view. In one of the respondent, my lord, here, respondent number 90, respondent number 99, my lord, his case is different. I am not representing him. This, his case was considered in terms of your lordship's order that is reflected in page 286. Lordship's order to the WPC.
Which is the order?
Yes, sir, I am giving it one. I thought extra some.
You thought there are direct recruits coming behind you. No, this-
Fireworks are required.
Yes, yes. Now the courts are also using technical gadgets to participate. All right.
Now your lordship will kindly look at page 216 of the affidavit in opposition filed by us, my lord.
Yes.
216.
My lord, can I just chip in, my lord, with your lordship's kind permission? Now, my lord, to determine when the direct recruitment vacancies arose, because lordship will have to take a call that both the vacancies arose in 22. The state has not come up clear on that. Direct recruitment vacancies arose when?
No, Mr. Chaudhary, what they are projecting.
Yes.
And this is for you to respond to.
Yes.
The question as to when the vacancies of direct recruit arose has nothing to do with rule.
It has got, my lord. Otherwise, why the word used is in a vacancy here? Otherwise, my lord, suppose in
Just 1 minute.
then your lordship compare with what?
What their argument is that
Yes.
the edict of Rule 22(3) is that
Yes.
the vacancies of promotees must arise in the same year in which year the direct recruits are appointed.
No, my lord, that doesn't say so.
Yes.
Kindly see, my lord.
Please see the rules once.
A member appointed by promotion against a vacancy occurring in a year shall be senior to a member appointed by direct recruitment of that year.
Yes. So direct recruitment vacancy arising is not an issue in the Rule 22(3).
No, no. Naturally, my lord. Otherwise, my lord, what meaning lordship will give? That's why I said, my lord, this information will be necessary. That's why I thought, my lord. Then my lord will kindly come to 6A, Rule 6A for a moment.
No, Mr. Chaudhary,
Ah.
you make your response, but just to point out that the projection, you were not there in between for 5 minutes. The projection of Mr. Quach, which may or may not be acceptable, that is another matter, is that 22(3) revolves around two propositions. One, in case of promotees, what is significant is the year in which the vacancies arose. In case of direct recruits, what is relevant is the year of their appointment. The question as to against which vacancies these direct recruits were appointed
Is not relevant.
is not the issue coming within 22(3). That's their argument. You can meet it. So, although the government department has filed affidavit saying that all 106 vacancies arose in 2020.
Let us accept it, my lord.
But even if that is accepted or disputed, that according to them is of no relevance, because two things will be relevant, which is the date of appointment of the direct recruits, year of appointment, and which is the year in which the vacancies arose where the promotees were appointed. These are the two parameters under Rule 22(3). That is the projection here.
Anyway,
So
got
therefore,
it.
maybe you were out when this.
So your lordship will now kindly look at page number 216. 216.
216.
Copy today. More copy today. Advertisement today.
Yes,
Mala 216 at paragraph number 8, the clarification on the vacancy calculation. That the deponent state that for the year 2022, there were total 106 vacancies civil, which are to be filled up by way of promotion of junior engineer civil. As per Rule 11.4A and Rule 11.4B of the rules of 1970, the candidate who have completed a minimum of 8 years of service at JE Civil and have successfully undergone training and passed the departmental examination as prescribed by the government from time to time are eligible for consideration. Then your lordship will find at the next page the breakup. Malad, the total cadre strength is page 217. Your lordship will find the breakup at page 217. 756 is the total cadre strength in the table, my lord.
Yes.
And 227 is this 30% is from the promotees, 70% from the direct recruit. If you calculate 30% of 756, then it is 227. Then existing vacancies out of column 2 is, my lord, 106. So this is how they have calculated. Then your lordship will find that column, the total strength is given, man in position, vacancy, roster point is given. This is of the mid part of 2022. So far, the 2023 vacancy that your lordship will find in the next page at page 218.
Yes.
Breakup of the total can, this is of 2023. So if on the last, when my learned senior was submitting, he said that these are anticipated vacancies of 2023. No, it is not the anticipated vacancies of 2023. For 2023, there was a separate calculation for their vacancies. All these 106 vacancies are of the mid part of 2022.
So in sum and substance, you are saying that 106 vacancies are all of 2020.
2022. Now your lordship will kindly see, I had
Yes.
basically, my lord, I have your lordship may just look into the issues that which may call for your lordship education that I have formulated at page 210.
210.
210, 210.
Yes.
First is, my lord, the first issue is, my lord, whether Rule 22.3 of the Assam Engineering Public Works Department Service Rule 1970 has been correctly interpreted and applied in determining the interstate seniority between direct recruits of 2022 and promotees promoted in 2023. Next is whether the private respondent who were promoted in 2023 can be assigned seniority over the petitioners who were directly recruited in 2022 merely because the promotion was made against vacancies of 2022. Then third is, my lord, whether the rejection of the, because they have also challenged the rejection of the petitioner's representation. So that is the third. Fourth, my lord, relaxation, they are not challenging. So the fourth issue is no longer live now. Now your lordship will see the case laws relied on by the petitioners. Citation card दो तो मेरा office copy. कोर्ट के लिए भी एक कॉपी दे दो. हाँ? मार्क, इनाम मार्क किया हुआ दो, क्यों कौन मार्क किया? नहीं, मेरा मार्क को मेरा तो मार्क है, आपका कोर्ट का मीना मार्क किया हुआ दे दो.
What?
No, they said that mine is marked. I said that.
Don't be so.
I said that give the unmarked one to the court. Your lordship will first look into Veram at page 11. 1, 2, 3, I have marked page 11.
Yes.
Now in Veram, my lord, your lordship will look at paragraph number 5.
Yes.
Just one line. My lord, your lordship will look at paragraph 5. My seniors refers it at placenta. I sometimes refer it as parenthesis. So your lordship will look at the E prefix. That is, a person who enters in the service first shall rank senior unless there is some rule providing otherwise which can be held to be consistent with Article 14 and 16 of the contract. So, Veram, the rule was not there of in regard to year of vacancy. So this is, so in Veram itself, it clarifies that if there is a rule, then the rule will prevail. Unless there is ambiguity or the rule challenge is made to the rule on violation of Article 14 and 16. Then the other.
So since you are referring to this, how is this rule? How is this rule consistent with Article 14 and 16?
But there is no challenge to it, my lord.
Ah, that's the only reason. That's why I've been asking thrice.
There is no challenge to it. Yes.
Till the time the rule is under challenge.
That will.
No further.
Yes. Your Lordship.
Otherwise, what is the logic of this rule?
Yes.
You're lucky that they have not challenged it.
And your Lordship will see this rule has given sweeping powers to the government also. Rule 28, if your Lordship looks into it, in some of the rules, in all the cases where the relaxation is there, it says that the rules of recruitment can't be relaxed. Only the rules of eligibility can be changed in some cases. And they have specified which part of the rule then that can be changed. In this rule, in case of any rule, the relaxation can be given.
But then, unless these are challenged,
Yes.
the court will
So
not.
your Lordship is not called for to answering. Your Lordship has only this basic interpretation of Rule 22(3). And Vedam says that if the rule says, then the matter ends there. Even in the case of, my lord, the other case at page number 1, my lord, that is State of Bihar, Akhori Sasindranath's case, my lord. My learned friend has referred to the paragraph 12. But if your Lordship looks into the entire facts of the case, my lord, your Lordship will find that the in 1961, the direct recruits were appointed. And the promotees were promoted in 1962, but they were sought to be given retrospective promotion from 1961. That's why this case is not applicable.
Yes,
Then-
anything else?
Yes, madam. I'll just distinguish those cases
You can
first.
conclude now.
Yes. The next is, my lord, Jagdish Chandra Patnaik, which my learned friend has referred. That is at page 16. In Jagdish Chandra Patnaik also, my lord,
Yes.
if your Lordship looks at page 24, this seniority rule is completely different, my lord, at Rule 26, page 24.
No, those things have been.
Yes, yes.
When Mr.
Then your Lordship will look at the next judgment, that is 2011 4 SCC. Last occasion they referred the other judgment, and today they are not referring. Ultimately, my lord, at the end of the day, what it is comes out is that whether Rule 23, which says that it occurs in a vacancy of a particular year, and the year has been referred as the calendar year. This calendar year will be from 1st of January 2022 to 31st of December 22. Within those time, the vacancies will be applicable. And all the case laws which my learned friend has referred, there are all the seniority rules, the relaxation rules are not in perimetry with the rules of Assam. Rules of Assam is a unique rule, as your Lordship has said, unless a challenge is made to that. So I respectfully submit that so far the seniority list is concerned, we have been rightly placed above the direct recruits in the seniority list.
Insofar as the 22 Rule 22(3) in the present form is concerned.
Yes,
That's all.
yes.
No further.
Well, your Lordship will
Present form.
yeah.
You have yourself said that
No, madam. Yes. No.
Since
Madam,
on a
this-
query by the court, how it is consistent with Article.
no, I have not addressed your
You
Lordship.
said that it is not under challenge.
Yes.
Beyond that, you could not say anything.
No, Malad, what has happened, Malad? In this rule also, there is a Rule 12(1). Rule 12(1). Your Lordship will kindly see Rule 12(1) of the rules, madam.
Yes.
12(1) at page 9. It says, my lord, we were assistant engineer, civil. So our next post is assistant executive engineer is our next post. So what the government tried to do by Rule 12, by that proviso, was that 20% of that post in assistant executive engineers were reserved for promotee. Then this was put into challenge before this honorable court, and the honorable court quashed it as arbitrary and unconstitutional, and the whole rule was quashed. Then, my lord, the matter went to the Supreme Court. At present, that rule is under sub judice before the
Which is that rule?
12 proviso. 12(2) proviso. Itu asan gitu so. Nah. Di sini kata. Well, provided that 20% of the total cadre strength in the cadre of assistant executive engineer and 20% of the total cadre strength in the cadre that shall be reserved for being filled up by promotion from the promotee. This is now has been set aside by the.
That's not the subject.
So,
matter.
so
that's
basically
anything
that
else
is, this is the issue. As long as the rule stays and there is a specificate that says that it is the vacancies of 2022. All the records, it says that it is the mid part of the 22-23 vacancies have been calculated. So far, the direct recruits are concerned, Malad, these were all vacancies of 2019 and 20.
That you have said, Mr. Khan,
No,
you have said.
even in the advertisement, it is reflected in that. Yes,
That you have said.
yes, yes.
Anything else?
No, if subject to what my learned friend says.
Yeah, Mr. Nayak, whatever has been argued, there is no need to go into. If there is
Yes,
anything,
I'm only pointing out
But
two,
be-
three basic
because-
things, Lordship.
I want to ask you this. Though it is not under challenge, but how 22(3) is in consonance with Article 14 and 16, according to you?
Lordship, first thing Lordship will consider the direct recruit will enter at the very inception, Lordship. But the promotees, that these promotees are working there for more than 20 years. They are at the verge of retirement, Lordship. They will not, even if they are promoted, Lordship, they will hardly work for 1 or 2 years, Lordship. They will retire. So that was the consideration given, Lordship.
So one would have understood if you said that in case of vacancies arising in the same year,
Yes,
promotees will rank above direct recruits. That
Yes.
is understandable.
yes.
But what you are saying, perhaps, is that even if the vacancies arose 3 years back for direct recruits, their appointment in the same year will take a second fiddle to the promotees if the vacancies arose. So therefore, you are saying that later vacancies will get seniority over prior vacancies.
In case of direct recruit, definitely not, Lordship. But
Huh?
if it is promotion, Lordship,
That's-
the
that's what-
comparison in between promotees and direct recruit, Lordship.
Not going
And secondly,
to-
Lordship, this is not the specific in respect of PWD only, Lordship. Lordship will find
That is
similar
another
in
matter.
case of other departments.
PWD or any authority, that's not the issue.
And Lordship, as this rule is not under silence, Lordship, I am on that. not that.
Answer you have.
I'm only pointing out 2, 3 things, Lordship. In the gradation list, Lordship, final gradation list at page 155. Lordship, from serial number 1 to serial number 80. There is no objection, Lordship. They have no grievance against them. 1 to 80.
You're referring to page number
It
155.
starts from page number 155 of the writ petition, Lordship.
Okay, that is your counter affidavit.
No, writ petition, Lordship.
Read petition, yes.
From serial number 1 to serial number 80, these are all promotion prior to the direct recruitment of the petitioner. So they have no objection in respect of 1 to 80. So that is the first. Secondly, Lordship, they are aggrieved against 81 to 176. These are the ones.
Incidentally, those are promoted in 2021.
Yes,
Their appointment is of 2022.
they are appointees of September 2022.
Yes. So how can they have grievance against 2021 appointees? They can't.
No, Lordship, what I'm trying to submit, Lordship, nothing to, whatever your Lordship passes in any order, Lordship, that should not affect this 1 to 80, serial number 1 to 80. That is my
Certainly,
first submission.
certainly,
Lord.
certainly.
Secondly, Lordship, so far as Rule 22(3) is concerned, there is no ambiguity, Lordship. So this honorable court have made some reservation so far as 22(3) is concerned. But unless and until it is silenced, Lordship,
Correct.
court will not definitely interfere what is there. Thirdly, Lordship, one judgment, Lordship, in several judgment has been placed, Lordship. One
No,
judgment.
no, court doesn't have reservation. Court is asking, how is it in consonance with the spirit of Article 14 and 16?
Yes, Lordship.
But then the question cannot be pursued because it is not under challenge.
Yes.
That is your response.
Yes.
That much, nothing beyond that.
My entire affidavit has already been read, Lordship, so I have nothing
Yes,
to add.
yes, yes.
So one judgment, Lordship, I am placing 2022 SCC online 1559. So I am referring to paragraph 20, Lordship.
Paragraph 20.
Yes, Lord.
Yes, please.
Lordship, this code, paragraph 20 at the bottom, Lordship.
Mhm.
This court, in the case of Pawan Pratap Singh versus Rivant Singh, observed us. Lordship, I am skipping this portion. I am coming to the next page, Lordship, paragraph 45. Roman 4, Lordship. The seniority cannot be reckoned from the date of occurrence of the vacancy and cannot be given retrospectively unless it is so expressly provided by the relevant service rule. That is what I am submitting, Lordship. Another judgment I am placing, Lordship.
Yes.
This is 2006 10 SCC 346. Paragraph 30. Detail no? Directly quotes. Just one paragraph 34.
Yes. Yes, please.
That is the only book I have got.
Correct.
So in my affidavit, Lordship, only one page I am referring to, Lordship, that is 177. This is the minutes of the meeting dated 7/12/2022. This is regarding the vacancies of 2022 only, Lord.
Page number 177.
Yes, Lord.
Yes.
Lordship, paragraph 2.
Mhm.
As per Assam Engineering PW Service Rule 1978, the vacancies to be filled up in the
No,
cadre of
just a minute. You are reading 177 of which?
177 of my affidavit, Lordship. Lordship, the extra copy. Yes, Lordship. Close to.
There is some problem with the pagination. Your affidavit starts from page 261.
Yes, Lordship. 261.
Then you are
At
reading from
page
one-
177. 177.
There are two affidavits, Your Lordship.
page
My one.
261
It starts from
affidavit starts.
261. Yes.
Then
I'm-
page 61, if it starts, how can we go to 177?
277.
277. You are saying 177.
270.
Hmm.
Second paragraph, Lordship.
Yes.
As per Assam Engineering PW Service Rule 1978, the vacancies to be filled up in the cadre of assistant engineer from the rank of junior engineer by promotion should not exceed 30% of the total corresponding cadre strength of permanent and temporary assistant engineers. The total cadre strength of assistant engineers is 756. This implies that 227 posts, that is 30% of the total cadre strength, 756 numbers of assistant engineer civil, are reserved for promotion from JE to AEC. Out of these 227 posts, 167 numbers of posts are presently lying vacant due to promotion superannuation. So these are the remaining vacancies, Lordship. And as regard year, Lordship will find that in the final order passed by the department at page 183 of the writ petition.
Yes.
Page 183, second whereas, Lordship, and whereas.
Yes.
Second paragraph, Lordship, and whereas the PWD held a selection board meeting on 7/12/2022 for promotion of junior engineer C to the rank of assistant engineer C under the joint cadre of PWD and PW Building and NH department. Accordingly, 106 numbers of junior engineer civil were recommended by the selection board for the existing vacancies of the year 2022.
Okay, so you are saying these vacancies are of 2020?
All 2022. But that much only.
Yes.
I'll just give you a short reply for a clarification. Your lordship will kindly look into the citation at page 24. Hey, Jagdish Patnaik.
Yes.
Now your lordship will see the seniority rule in Jagdish Chandra's Patnaik case at paragraph number 24.
Yes.
Seniority, when officers are recruited, yes, especially use the term recruited. By promotion and by direct recruitment during the same year, the promoted officers shall be considered senior to the officers directly recruited, irrespective of the date of joining of appointment. Now your lordship will look into paragraph number 32.
Yes.
The next paragraph 32, the next question for consideration is whether the year in which the vacancy accrues can have any relevance for the purpose of determining the seniority, irrespective of the fact when the persons are recruited. Mr. Banerjee's contention on this score is that since the appellant were recruited to the cadre of assistant engineer in respect of the vacancies that arose in the year 1978, though in fact the letter of appointment was issued only in March 1980, he should be treated to be a recruit of the year 1978, and as such would be senior to the promotees of the year 1979 and 1980, and would be junior to the promotees of the year 1978. According to the learned counsel, since the process of recruitment takes a fairly long period, as the Public Service Commission invites application, interviews, and finally selects them, whereupon the government takes the final decision, it would be illogical to ignore the year in which the vacancy arose and against which the recruitment has been made. There is no dispute. There will be some time lag between the year when the vacancy accrues and the year when the final recruitment is made for complying with the procedure prescribed. But that would not give a handle. This is important. But that would not give a handle to the court to include something which is not there in the rules of seniority under Rule 26. Under Rule 26, the year in which the vacancy arose and against which vacancy the recruitment has been made is not at all to be looked into for determination of the interstate seniority between direct recruits and the promotee. It merely states that during the calendar year, direct recruits to the cadre of assistant engineer would be junior to the promotees recruits to the said cadre. It is not possible for the court to import something which is not there in Rule 26 and thereby legislate a new rule of seniority. So here also, my lord, this rule of Rule 12 is completely different from all the case laws cited by my learned senior, especially Rule 22, rule in determination of the seniority between direct recruit and the promotees.
My lord, having seen the proceedings, my lord, I'll require some time to reply. Not much. Monday.
Monday.
Lord, last argument which my learned friend made, that will be very dangerous for him. That I can reply. But I am thinking on some other angles. Just now he referred to para 32, that will go against him. But otherwise, my lord, whether I am required to challenge 22.3, that is an aspect which we'll have to consider in consultation with
No,
our
that's right,
clients.
but then, see, Mr. Chaudhary, please appreciate this. This matter has been finally heard.
Yes, yes.
So,
Only thing is, my lord, perhaps that will be the decision. The only thing is, my lord, without consulting the clients, I would not like to take that call.
no, that's fair enough.
In all probability,
But supposing you want
we
to
will
challenge,
take a call to challenge 22.3, where we
then
stand.
also this matter, either you have to withdraw or the.
No,
I have
that's
to
what, my
close
lord.
it.
Only thing, and lordship will defer this consideration only till Monday 10:30.
Monday, till Monday.
My lord, I'll pray till Tuesday. My lord. I'm leaving for Kolkata today.
Nothing, he will just give his reply.
my lord,
In all
report.
probability, I'll have to withdraw and challenge that.
My lord, 25.
You
Tuesday.
said it already.
My lord, I have given my thought. No?
Tuesday.
Tuesday, my apathy nahi.
He has no objection for Tuesday.
Oh, sorry, Tuesday night,
Wednesday.
Monday no go back.
My lord, only for Monday I am seeking
So,
accommodation.
Mr. Kaur, you have made your part. Don't worry. If,
Ah.
if anything is required from your side, we'll defer it.
Tomorrow, if he withdraws it and files it, my lord.
We'll have it on Monday. That's the only point. I think Mr. Chaudhary is also.
I have
taking- objective view of
End
the.
of the day, we also understand
Yes,
things,
yes.
Milord. Anyway, Milord, for 22-3 challenge as
No,
a
that's fair
critical
enough.
case, yes.
He wants to
Yes, yes.
have a conference. That's fair enough. Otherwise, he makes his reply, and if we want any clarification from him,
Yes.
we'll defer it, other we'll close it. Yes, heard Mr. Ken Chaudhary, and senior counsel listed by Mr. R. M. Decker, learned counsel for the petition. Also had Mr. P. Nair, learned standing counsel, PRW Assam, appearing for the respond numbers one and two. Mr. B. D. Paul and senior counsel listed by Mr. E. As appeared for the respond numbers
3 to 92
3 to 92
and 94 to 98.
and 94 to 98. Hard in part on the request of Mr. K. N. Chaudhary, learned senior counsel for the writ petitioner. List this case again on 24 so and so as a fixed part heard matter.
Well, my subject to your convenient, lordship's convenient case, my friend says that it can be taken up tomorrow also.
No, Mr.
Oh,
Kaur,
oh.
there is something called court's confidence.
Yes, yes,
convenience.
court's convenient.
That is what
Yes,
people
yes,
are
yes,
forgetting.
yes, yes.
It is not convenient.
Yes.
It's
We have.
Monday and we'll close
Yes,
it on
yes,
Monday.
yes.
That's it.
Yeah.
There are lots of things we are also in the middle
Yes,
of.
man, we are. We are always here.
Lots of things.
Yes, we are always here.
But just because you don't see,
No, no,
don't
but we
think that
see.
it is nothing.
We see. We see. I at least have the assistance of the genius, my lord. The court may not have the assistance of the lawyers to assist the court.
We have heard the matter.
Yes,
I
yes,
have
yes,
heard the
yes.
matter substantially. Mr. Chaudhary is also appreciating the legal issues here.
Yes.
It's fair enough. He wants to have a conference, we let him come back. Otherwise, on the legal issues, arguments are practically complete.
Yes.
Unless the court wants any clarification, we'll close the matter. If he withdraws, matter ends there. If he wants a decision, that he will decide. Because the decision may be this or that, but will it affect future course of action? That Mr. Chaudhary has a right to
Yes,
make a
ma'am.
decision on that.
It's a
Absolutely.
series of officers. Milord.
Absolutely.
It is a single individual. I would have.
Absolutely, Mr. Chaudhary, you are entitled to that. That is the minimum you are entitled to. There is no
Yes.
difficulty.
We have also no objection. My lord. He should have the time to.
Deeply.
May I please, your lordship, Madam, the matter regarding compassionate appointment, Madam. One of my prayer, Madam, apart from challenging their selection, Madam, to forward my name to SLC, Madam. And my instructions that my name has been already raised before the SLC. Now,
Then you will close it.
yes, Madam.
Yes.
I'm for
Mr.
respondent 6, my lord.
Huh?
Respondent.
Heard Mr. A. Chaudhary, heard counsel for the writ petitioner, also heard Mr. Anybody from the government, Mr. D. Boral, and its government advocate Assam appearing for respond numbers
4 and 5.
4 and 5. Who is for 1, 2, and 3?
1, 2, 3.
I'll go for it. He was here just.
Mr. R. R. Gogoi, Learned Standing Council,
Page.
PHE,
Oh, right.
has appeared for respond numbers 1, 2, and 3. Mr. P. K. Decker, Learned Counsel for the respond number 6
Six.
is also present. Mr. Chaudhary submits that the primary relief sought by his client in this writ petition was for a direction to the respondents to forward his candidature for consideration of the prayer for appointment on compassionate ground to the SLC. However, during the pendency of this writ petition, the learned counsel for, however, submits Mr. Chaudhary, during the pendency of this writ petition, no, you write like this. However, as per instructions received, Mr. Chaudhary submits that during the pendency of this writ petition, the name of the petitioner has already been forwarded to the SLC. In view of the above, with liberty to agitate further grievance in the matter, as and when a proper cause of action arises, Mr. Chaudhary seeks leave to withdraw this writ petition. The prayer is not opposed by the respondents' counsel. As such, the writ petition stands disposed of on withdrawal with liberty as prayer.
Oblige, oblige, minute.
Yeah. Yes, please.
Make please, your lordship. My lord petitioner before your lordship is a DRDA accountant, lordship. He has already retired, lordship. Now, only two things are there, lordship. His suspension period salary and as well as the claiming for pension because the RDA subsequently amalgamated with the government, lordship. And there was an order, lordship, of the earlier dishonorable court 29/11/22. Some issues were framed, lordship. And
Petitioner retired when?
retired on 31/5/2013, lordship.
31/5/2013.
13, lordship.
And this writ petition was filed in 2018.
18 earlier, some round of litigations was there, lordship.
All right. So what is the prayer in the writ petition?
Where in the writ petition, lordship,
To promote the petitioner.
regarding other juniors were promoted, lordship.
That can't be accepted.
Lordship, that part, lordship. But regarding
Financial upgradation also cannot be accepted.
pension, lordship,
Financial upgradation
financial,
cannot be.
lordship.
He is in a pensionable service.
No, your lordship, the DRDA is a registered society and subsequently in the 2016 government has taken a decision to dissolve it and those were directly recruited by the DRDAs. They were absorbing the government service, government, other government in equal rank post, your lordship. 2016.
Where is the
decision was
appointment order of the petitioner?
And he
Appointment
retired
of
in
the
2000.
appointment order of the petitioner, lordship. Annexure
Annexure.
1, page 24, lordship.
His appointment is by project director.
Yes, your lordship.
Lordship.
Project director of the DRDA, your lordship.
Correct.
And he retired as a DRDA employee, not as a government employee.
DRD,
No, no, this is not appointment order. This is the retirement order.
lordships. Page 24, lordship. Annexure 1, lordship.
There is no annexure 1 in page 21. Look at what you have given.
24.
What
Sorry,
is there in
lordship.
page 24?
Lordship, sorry, lordship, it was
You submit representation. 6 months, they will consider.
Lordship, he was appointed as DRDA employee by DRDA and he retired as a DRDA employee in the year 2013. Government taken decision to dissolve the DRDAs and to take over the directly recruited DRDA employees in the 2016 only. And ultimately, those DRDA employees were absorbed in the government departments in the year 2017. So he has missed the
All
bus.
right, we'll ask, who is the authority to consider your,
lordship commissioner. And nowadays, lordship, earlier to someone, the lordship,
commissioner, what?
commissioner PNRD, lordship.
Let him submit a representation. We'll,
Lordship, regarding my area, lordship,
all you submit representation, not Mr. K. Mazumdar, and counsel for the petitioner also heard Mr. K. Kaur, learned additional AG Assam appearing for the state. The writ petitioner hearing was serving under the project director of DRDA as accountant, full stop. He retired from service on attaining the age of superannuation with effect from 31/5/2013. Full stop. The instant writ petition has been filed primarily, filed seeking as many as 3 reliefs. Number 1, you write to grant promotion to the petitioner to the post of senior accountant from the date on which his juniors were promoted, semicolon. Number 2, to grant the petitioner necessary financial upgradation under the ACP scheme. And number 3, release the pensionary dues of the petitioner from the date of his retirement till today. Full stop. Insofar as the first and second prayer is concerned, there is consensus at the bar that after more than 12 years of his retirement, after nearly 12 years from retirement of the petitioner, none of these prayers can be considered by this court at this point of time. Full stop. Insofar as the third prayer for grant of pensionary benefit is concerned, Mr. Kaur has resisted.
May your lordship, here your lordships, he was working in a non-pensionable establishment. No? So his entitlement has already been released.
Not yet,
All right,
lordship.
you take your seat. Has resisted the prayer of the petitioner on such ground by submitting that the petitioner was engaged under the DRTA, which is a registered society, and the said society has since been dissolved. Since the petitioner was not a government employee, there was no question of granting pension to the petitioner. Full stop. The retirement dues of the petitioner, if any, was released to him long back. Under the circumstances, submits Mr. Kaur the question of granting any further pensionary relief to the petitioner does not arise in the eyes of law. Full stop. The submission of Mr. Kaur may be correct. However, since the petitioner is seeking pension after his retirement from service, he is entitled to an order from the departmental authorities redressing his grievance in the matter. Therefore, without commenting on the merit of the claim of the petitioner, this writ petition is being disposed of by granting 1 month's time to the petitioner to submit a detailed representation ventilating his grievance as regards non-payment of pension.
As well as lordship, the suspension, lordship, page 22,
And any other ancillary grievance.
lordship, page 22, next, D prayer, lordship.
Regularization of his period of suspension.
Lordship regarding salary of 25% salary, 75% was given lordship. Release of the outstanding amount of rupees 3,02,133 has not been.
Any other ancillary relief as may be desired by the petitioner. The representation be submitted before the, now, since the DRDA was functioning under the Department of Panchayat and Rural Development,
Principal Secretary, yes.
Government of Assam, the representation be submitted before the Commissioner, Panchayat and Rural Development Department, Assam, that is response number 4, but along with a certified copy of this order. If such a
Along with my writ petition also, lordship.
writ petition, counter affidavit, and anything
everything.
else you want to?
Lordship, everything.
You want the commissioner to decide the writ petition?
No, lordship.
Then why are you making
Sorry,
submissions?
lordship. Sorry.
Along with a copy of this order. Stop. If such, the representation is submitted within 4 weeks from today, the same be considered objectively and disposed of by a speaking order as expeditiously as possible, preferably within 6 months thereafter. With the above observation, we stands.
Lordship, that time maybe some petitioner is very unwell, lordship.
Can't help.
It may be 4 months, lordship.
6 months.
Now, this matter may be passed over for the timing. Mr. H. Gupta Mala appears in the matter. He is in another
No,
court.
who is for the petitioner? None appears for the writ petitioner when these petitions were called up before this court. Mr.
Why would we, my lord?
Why?
Would we, my lord?
Board we are learned counsel appearing for the respond number.
All the respondents, my lord.
For the
for chiefs.
respondents has sought a passover.
My lord.
In view of the above, and since the petitioner's counsel is absent today, these matters stand Admission hearing of these matters stand adjourned for 4 weeks. Please take on.
Much obliged.
Item 15.
Maybe your lordship has called for the review, relevant records regarding the review meeting on the last occasion, madam. This matter relating to the suspension of a government servant, madam. Pending the criminal, while he was arrested in the criminal case, madam. He was placed under
You were
suspension.
suspended when?
I was suspended on 31/10/2022, madam. And the review minutes was held on 21/1/2023, madam. Review committee meeting, madam. And thereafter on 2nd of February 2020, first extension was made. And thereafter on 3/4/23, madam, token notice was issued, madam. And I submitted reply on 12/5/23, madam. And the inquiry officer was appointed on 18/8/2023, madam. But the inquiry could not be
No,
completed.
your client was working under which department?
He was Home Department, my lord, as a joint secretary.
Department is not even a party.
He was suspended by Personnel Department.
No, maybe, but the Home Department has to be a party.
Because he was suspended by Personnel Department.
Personnel department will be doing the personal part of it. But is the
The
Home
suspension order was issued by Personnel Department. Because service book, everything was under the control of Personnel Department.
Yes.
Lordship, I have obtained record lordship, but one of the contention of the writ petitioner is that inquiry has not been completed, lordship, and the criminal case is pending. And they are telling it is in a very slow way, lordship. So I have obtained the record lordship, and in the record note sheet, it is there that it has already been observed and taken note of, lordship. And Honorable CM has already ordered that the inquiry to be completed and report should be submitted within 7th of April 2025, lordship. And that should be conducted in a fast track manner, lordship. So this is the updated instruction that we are
7th of
having.
April 2025.
25, lordship.
Now,
Inquiry.
That is about.
now the question is before also, my lord. Because first review meeting was taken on 21/10/21 of 23. That you have time enclosed, my lord. You will also kindly see, my lord, in the affidavit, my lord. Page
First review meeting was on 21/10.
21/1/2023, my lord. That is within 3 months of the date of suspension, my lord.
Right.
Page 49 annexure A, my lord.
Hmm.
Thereafter, there was, though they have, in their extension order, they have referred that there was a review meeting, but there was no such meeting, my lord.
After
word-
21 January, there was no review meeting. Miss Bhattacharya?
You'll also kindly see the extension order, my lord. That subsequent extension order, page 49, 50, 51, 52, my lord.
Lordship, it is part of the record, lordship, minutes of the review meeting, lordship, page 49.
That was only initial meeting. Their subsequent, my lord, extension was not based on.
No, Mr. Kothari, you see, these orders of the court
Yes, my lord.
and of also this judgment of the Supreme Court in
Yes.
Ajay Chaudhary,
Yes, I agree.
these are based on one fundamental principle.
Yes, understand. my lord.
That the employee should not be placed on suspension and then the proceedings are dragged indefinitely. The department loses out, the employee is harassed.
Yes,
So
that,
the whole idea was to expedite.
yes, but now,
Now, they are saying that the departmental proceeding is in an advanced stage and by 7th of April, it will be concluded. Number one. Number two, your suspension was reviewed within 90 days.
90 days were reviewed. Thereafter, my lord, there was no review meeting.
So is it the mandate of the law that every 90 days it will?
Because they have stated, my lord, on the basis of a recommend subsequent extension, there were more than 10 extensions were there, my lord.
Correct.
In all the extension order, you will also will find, considering the grave nature and charges against so and so, based on the recommendation of the review committee. But there was no, only one review committee was that.
No. Please understand the question.
Yes,
First review was there.
yes,
By that time, the departmental proceeding was initiated.
not initiated, subsequently after that.
When was it initiated?
It was initiated, my lord, that was initiated, my lord.
When was the charge sheet
Yes,
submitted?
I'm coming. Page 21, my lord.
3/4/23, Lordship. Show cause issued.
3/4/23, ma'am. And review meeting
So
was
within the 3 months of the, after the first review meeting,
after the first review meeting.
yes, within that period, the charge sheet was, the
Yes,
yes, ma'am.
proceeding
So-
was initiated.
Yes, sir.
Yes, yes.
So that means when the second review time of 90 days came in, by that time you were already subject to a departmental proceeding.
Yes, proceeding was there.
And the charges against you are regarding financial,
There was a corruption charges, my lord, because I
Bribery.
demanded money from somebody, my lord.
Bribery, Lord.
Bribery.
so is it a case where automatically they are being
Automatically,
subject
but Ajay Chaudhary says, your lordship, kindly, I am coming to that decision, my lord, your lordship has.
supposing they exonerate you from the charge.
Yes,
Well and good. Supposing there is anything in between, also fine. Supposing there is a major penalty, God forbid,
yes, ma'am.
then what is the purpose of this court now saying that reinstate him and dismiss him again? Will it not invite unnecessary? Why don't you wait for 7th April, let them pass the order?
But but already I'm going, since 22, my lord, I've been placed under suspension, your lordship.
Maybe. Ajay Chaudhary is not an idea that no more suspension.
Yes, ma'am.
Only 3 months suspension. That is not the idea under Ajay Chaudhary.
But it says, my lord,
Ajay Chaudhary says if you suspend people unnecessarily without any conscious idea of, then the courts will step in. That is okay.
your paragraph 12, my lord, says protected period of suspension, repeated renewal thereof, having regularly been not the exception. I've been repeatedly, it has been renewed from 2023 onwards, man. This 25, man. And a suspension for some ignominy of institution as form of the society, direction of department. And I'm going to retire in the month of February 2026, man. Your lordship, may kindly see the situation.
You conclude it. Otherwise.
Yes, Lordship. I also have the noting. I shall place.
Heard Mr. P. Kodaki, learned counsel for the petitioner. Also heard Ms. M. Bhattacharjee, learned petition senior government advocate Assam appearing for the state, who has produced the records called for by this court. From a perusal of the records, it appears that there is a strict instruction issued by the competent authority at the highest level to conclude the departmental proceeding initiated against the petitioner within 7th April 2025. Ms. Bhattacharjee submits that as per the aforesaid direction, the inquiry proceeding against the petitioner has already been fast-tracked, and the same will be concluded within 7/4/2025. It also transfers from the materials on record that the initial order of suspension dated 31/10/2022 was reviewed by the authorities on 21/01/2023, that is within the period of 90 days as prescribed by law. Whether this subsequent extension of the order of suspension was based on proper review of the order, and if not, whether in the light of the initiation of the departmental proceeding against the petitioner on 3/04/2023 would have a vitiating effect on the suspension of the petitioner, are undoubtedly issues which call for consideration by this court. However, since the departmental authorities have assured that the inquiry proceeding initiated against the petitioner would be concluded on or before 7/4/2025, and considering the nature of charge brought against the petitioner, this court is of the opinion that it will be prudent to defer the consideration of the writ petition on merits till 10/4/2024. The writ petition be listed accordingly, the records be taken back.
Lordship.
Let us see, because we have to balance out.
Yes, ma'am.
Deeply obliged, Lordship.
My lord, I'm very sorry, my lord. I've used the item 13 and 14, my lord. As the pension matter, my lord.
You
Since
can
the-
choose a date, but I have already passed an order. I'll not take it.
Can it be after a week, my lord? My lord, since pension matter, my lord.
Lordships, my lord, that item 16, my lord, yesterday I have received the Parawaz comments. I'm going to file an affidavit.
Just a minute, 13 and 14, then make
Okay.
after 10 days, after 10 days.
Extremely sorry, my lord.
Rest will be same only after 10 days. Yes. Yes, item
16 Lordship, just yesterday I have received the para-wise comment. I'm going to file an affidavit Lordship, within 2 weeks. Lordship.
What is this also suspension?
Yes, my lord.
Is there an interim order?
No interim order.
What is-
Departmental and inquiry has already been completed, Lordship. My lord, let me file an affidavit.
An affidavit on what? His grievance is that it's a case of prolonged suspension without proper review.
It was timely, it was reviewed. Lordship.
Huh?
Timely, it has been reviewed.
Yes, timely reviewed, departmental proceeding initiated within time, no issue. But the law is, there are certain parameters on which the incumbent.
All right, when will you file the affidavit?
Within 2 weeks.
No. 2 weeks, you've received your instruction.
Lordship.
We'll have it next week. You file it within next Wednesday, we'll have it on Friday.
Yes.
Okay, done. Heard Mr. J. Patori, learned counsel for the petitioner. Also heard Mr. J. Henry, learned standing counsel for the Revenue Department, Assam, who submits that he has received instructions and therefore be granted 10 days time to place the same on record in the form of an affidavit. Ms. M. Bhattacharjee, learned additional senior government advocate, Assam, is present on behalf of the state. Considering the nature of issue involved in this proceeding, I am inclined to grant time to the learned standing counsel for Revenue Department till 26th of March 2025 to file the affidavit by serving advance copy upon the petitioner's counsel. This writ petition is directed to be listed again on, you want it on Friday or on Monday? All right.
In the meantime, I can file my reply if required.
Then we'll have it on 1st of April.
Yes.
1st of April.
Yes.
Then
Did-
we'll give him one more day, 27th and 1st of
No
April.
issue, ma'am.
All right.
Obliged, Lord.
Lordship, as per last court order, Lordship, we are directed to produce the records. Records are available, Lordship.
Your Lordship, in this matter, I'm led by Senior Counsel Mr. Didas. Today, there is some difficulty. It is not inconvenient to your Lordship. Can it be after, in the month of April?
Mr. R.M. Das, learned counsel appearing for the
Water Resource
Water
Department,
Resources Department submits that the records have been received.
Lordship.
However, the learned counsel for the writ petitioners has sought posting of this matter on some other day in the month of April on the ground of non-availability of the learned senior counsel engaged in this case. In view of the prayer made by the petitioner's counsel, this writ petition is directed to be listed again after the reopening of.
Lordship.
There is an interim in this matter.
No,
Interim
no,
order.
no interim.
Interim is there.
No. Not to disturb the meeting. Not to disturb the meeting.
Let us see the record. There's an interim order, she said.
Lordship, there is an interim.
What is the date of the interim order?
Lordship, 22/1/2025.
Yes, there is an interim order.
Lordship, I'm sorry. That's
Interim
not to
order
disturb the
earlier
meeting.
continue.
Lordship.
Yes. You are appearing, Mr. Pokat.
For orders, I can review.
And it's a review against page 29, 129 order, by which 4 writ petitions were disposed of with certain directions.
Review page
129. We kindly come to page 139, para 12.
Page 139, is it?
139, para 12.
Yes.
May I read, my lord?
Yes, please.
Responding to the plea raised in this writ petition, Mr. So-and-so, learned standing counsel, Forest Department, has submitted in his usual fairness that as per the departmental records, the appointment of the private respondent as forest rangers does not appear to be based on any valid selection process conducted by APAC. And to that extent, he is not disputing the claim of the writ petitioners that they having been selected by the APAC in a valid selection process and their names having featured in the list of selected candidates of forest rangers published by the APAC the private respondent who were recruited subsequently and were below the petitioners in order of merit ought not to have been treated as senior to the petitioners in service, nor could they have been promoted to the higher post ahead of the writ petitioners. Mr. So-and-so, however, submitted, although the department is accepting that there is some anomaly in the process, yet considering the long years of service rendered by the private respondent, and in the interest of proper functioning of the department, this court may not interfere with the appointment and the promotion given into the private respondent. The learned departmental counsel so-and-so also assured this court on instruction obtained by him that if a direction is issued by this court, the seniority position of the writ petitioners would be restored in terms of poem dated so-and-so, as reiterated by notification dated so-and-so, and consequently the service benefits would also be given to them as per law. Now, based on this submission, my lord, the writ petition was allowed. Now, this submission, my lord, is factually incorrect. It's contrary to the record, at least so far as this present review petition is concerned. My lord, there are 4 private respondents, including this review petitioners. So far as this review petitioners are concerned, my lord, he was validly recruited following a due selection process. These are all matter of records. Admitted facts, my lord.
No, but submission, whatever submission he made, that cannot be a ground for review of the order.
No,
Sorry.
kindly see, kindly see this page 14 direction. The reasoning is at page 14.
Yes, page 14 or para.
Sorry, para 14,
Yes.
14, page 140. After hearing the argument advanced by the learned so-and-so, and on a careful scrutiny of the materials on record, this court is of the view that the writ petitioner herein were duly selected by the APSC for recruitment in the post of forest rangers, when are also subjected to training. As for the merit position, the APSC select list dated so-and-so, the writ petitioners undoubtedly ranked higher than the private respondent. Under the circumstances, the question of treating the petitioner as junior to the private respondent did not arise in the eyes of law. The learned departmental counsel has failed to convince this court that the recruitment of the private respondents as forest ranger were pursuant to a valid selection process inducted in accordance with law. If that be so, the question of giving seniority to the private respondent above the writ petitioner cannot arise in the eyes of law. So
It's
on
a
that,
wrong, erroneous judgment. You challenge it in an appeal.
on the face of it, madam,
No. This is not a case of review. You challenge it if you are having grievance.
madam, kindly see. So far as this
You
private
conclude your
respondent,
argument, but I'm not entertaining the review. According to you, it is an erroneous finding by the court.
madam,
Challenge it in an appeal.
review when the error is apparent on the face of the record.
No, it's not apparent.
I will show from the record, my lord. Can you see? Page 13, kindly see page on the face of it, my lord. They have admitted that is a factually incorrect statement. So far as the present review petitioner is concerned, there are 4 writ petitioners, my lord. Sorry, private respondent. I'm one of those. My case is different from the other 3. They've clubbed it. Kindly see just for a moment.
Mr. Nath, all I'm saying is that, first of all, it is doubtful whether there can be error in the judgment. That error could be because of misreading of the documents and evidence on record. That is also an error.
Yes.
But all errors are not subject to review.
Kindly see.
It is subject to correction by appellate tribunal.
Absolutely. When the
All I'm
error,
saying is to accept your argument now, then the writ petition be recalled, reheard. I'm not doing
kindly
it.
see this.
I'm not, I've read it.
That's all right. But for my satisfaction, kindly just for a moment, peruse, my lord, page 63. There's the appointment order.
Page 63.
Page 63. That's the appointment order.
Mr. Nath, I'm again and again saying this is an erroneous judgment. But it's not a case of review. That's all I'm saying.
But a review when it is on the face of the record.
Maharaj, I can clarify. But all these years he didn't appear before this court. He's piggybacking on other 3 petitioners. What I meant.
But I will hear it
Yes.
first. He has a right to argue.
But I can clarify it can end up in a.
Let him argue.
Only because this was not pointed out in the read proceeding, that it may not that this is not an error. It ought to have been pointed out. I agree. At the very first place. Kindly see, this is the notification, my lord, dated 28th of June 1989. Pending finalization of draft service rule so-and-so is pleased to appoint the following trainee officers who are undergoing Rangers course training at so-and-so temporarily against the existing vacant post so-and-so. The appointment on regular basis will be issued on successful completion of so-and-so. Can we see it against serial number 13?
You're referring to page number?
Page 63, man. That's the appointment order.
Yes.
Against serial number 3. That's the present review petitioner.
Hmm.
He was appointed along with the writ petitioners.
No, his name was within the 18 of the.
Yes,
APSC.
yes,
Wait,
very
huh?
much.
But that was, my lord, I was making submission beyond the 18. I didn't say that he's particular specific, he's beyond the 18. I was trying to save the beyond 18 people. It is admitted fact he's in the 18, original 18. That's all, my
Okay,
lord.
so he is the only review petitioner.
Yes.
Yes.
All happened because he didn't come and join the proceedings. All years.
No. Record will reflect that counsel appeared for this private respondent. Admitted fact, it is not pointed out. I agree. It ought to have been pointed out. But factually erroneous statement made.
No, it was qua the beyond 18. It was not regarding him.
But the judgment did not reflect that. It says all private respondents. There are 4 private respondents. My case is distinguishable from that
4
point of
private
view.
respondents were there in the before the court.
Before the
But why were you a part of it? You were also made a respondent?
Yes.
Respondent number?
At that proceeding, my lord, there are 4 writ petition, my lord. I was a party in 2 out of 4. I'm just giving the number. In WPC 1148/2021, I am R10, my lord. And WPC 4948/2020, I am R10, 9. I am R9.
Then why were you made respondent? Why were you included as a respondent there? If your selection, your appointment was pursuant to a valid APSC selection.
Yes.
Then why were you made?
My lord, here the dispute is regarding the criteria of seniority for fixing interstate seniority of forest rangers. The question is whether this interstate seniority will be fixed on the basis of merit in the APSC select list or on the basis of merit in the list prepared by the training college at the end of the training, 2 years training. That's the dispute. That's the dispute. Now, in the 4 writ petitions, they have challenged several
So
things.
originally only 18 posts were,
My lord,
18 posts
APSC
were
issued
there.
an advertisement for 18 stipendiary scholarship of 89-90 ranger course
But
in forestry.
APSC had furnished a list of more than 18.
44.
44.
Now, thereafter, the government by applying roster appointed 18. I'm one of those 18. Along with the writ petitions, admitted fact, man. Admitted fact.
Then why were you implicated as a respondent?
Because they have challenged, my lord, certain notification.
Then you
My
are for all
promotion.
purposes, you were one of the writ petitioners. But you should have been one of the writ petitioners.
No. I'm one of the.
If I may clarify. So the issues which are raised in the writ petition were twofold. One is that the APSC merit list should have been followed in determining the seniority. And the second issue which was raised at the threshold that your lordship had decided was that candidates who were outside the 18 were appointed and that superseded the petitioners. Now, I'll just take your lordship to 2 pages of the entire review petition, and that is where my case rests. Page 1.
What your case? He is the review
No,
petitioner.
the reason I'm saying stating.
Are you arguing on his behalf?
No,
or-
I'm not. In fact,
Then your turn has not yet come.
Then your lordship's order helps him. Actually helps him. That is my categorical submission.
That is his reading.
Yes.
My reading is entirely different. Because if lordship consider the direction, 3 directions is given while allowing the writ petition. 1 is to redraw the seniority list of 1989-90 batch as per 11/2/2020 notification. That is the first direction. Second, consider the case of the writ petitioners for promotion, considering their seniority position in the redrawn select list. And third is to give them consequential seniority in the promotional post and other service benefits. So these 3 directions will indicate that my lord has read retrospectivity in 11/2/2020 order, notification. 11/2/2020 notification, my lord, on the face of it, doesn't show it was given any retrospective effect. 11/2/20 notification cannot apply to 1989-90 batch, not at all.
All right, we'll continue after that. What is the other, which other matter is there today? Who is there? Who's there in that matter? Yes. What is your case?
My case is expediting departmental proceeding, subsequent dismissal from service. Now, what has happened? I was lordship posted in a high altitude place. So when I was posted in a high altitude place, lordship, I developed some problem with my breathing. So with permission, I came for a treatment. I treated. My doctor advised me don't go to high altitude. Even then, I was posted in a high altitude. My condition again deteriorated, lordship. Then I have to come, and the problem arose what? I overstayed, lordship. Then what they did?
So you are dismissed. Don't start arguing your case.
Revoked, lordship.
Is this matter ready for hearing today? Both sides are ready?
We do it after Bihu vacation. I am getting some judgments, lordship.
It's up to you. You want to do it, do it. If you want it after vacation,
I
you
have
do it.
prepared the factual aspect.
Oh, I'm not asking you what have you prepared. Do you want to do it today or you want to do it after vacation?
After vacation.
Mr. A. Bhattacharya, learned counsel for the writ petitioner, and Miss R. Devi, learned CGC appearing for the respondents, have both prayed for adjournment of the hearing of this writ petition with a request to post the matter after the Bihu vacation. Since a joint request has come from both the sides seeking adjournment, the prayer stands allowed. Although it is an old matter, the prayer stands allowed. Register to list this case for final hearing after the reopening of the Bihu vacation. So that means we have only the review petition. Yes. We'll take up the review petition at 2. Acha, give me the basic facts. How many writ petitions were disposed of?
4 writ petitions, man.
4 writ petitions. Okay, review petitioner was respond number 9 in?
9 in WPC 4948 of 2020.
WPC 4948
of 2020. And I am R10 in WPC 1148 of 2021.
WPC 4?
WPC 1148 of 2021.
So you are a part of those 18?
18.
Originally recommended by the APSC?
APS.
Where is that list?
Page 63.
Page 63 is the appointment order, man.
That's serial number 3.
No, 13, madam, 13. Dibakar Das. 13, 13.
But where is the APSC recommendation?
Right. At page minus 61. My name at 31, man. Serial number 31.
Okay, this list was forwarded by APSC for 18.
For 18, for appointment of 18.
But you came in the 18 by virtue of your
Roster.
roster.
By applying roster, this out of 44, recommendee, this review petitioner was appointed. Now, may I just indicate the facts, man.
Yes. Yes.
Subsequently, my lord, these selectees were sent for training.
Hmm.
It's a 2 years course, my lord.
Hmm.
After completion of training, my lord, on 25/9/91, the training college published a rank list on the basis of my performance in the final examination. Kindly see page 25. I ranked second there. I scored 70.70%. Whereas this writ petitioner number 1, my lord, he was unsuccessful in 3 subjects. And this writ petitioner number 2, he was unsuccessful in 1 subject. Kindly see page 25. That will show it, madam. That is the rank list, madam. Final order of merit.
This is in the Forest Training College.
Forest Training College. Dibakar Das at 2, my lord, 70.70%. Now, 4th from the bottom, my lord, Sahadat Ali. That is the writ petitioner number 2. Lordship will find his percentage is 59.48, and against the column number 6, where is the subject failed in was displayed, my lord, he failed in utilization. Then kindly come to page 26. My lord, 3rd from the bottom. Page 26.
So we'll clarify that since the petitioner was a part of the duly selected candidates
No, no,
by
the
APSC.
question is, my lord, whether the inter-C seniority will
That
be
will
fixed.
that cannot be changed. We'll only say that the reference to private respondents in the context of this order was in respect of those candidates who were not part of the APSC select list. But the petitioner was, the review petitioner who was respondent so-and-so was actually a part of the APSC select list. Therefore, these observations will not apply in this case. That's the only order I can pass.
My lord, this order will show that my lord has read retrospectivity in 11 to
That you have to check.
Kindly see,
That you have to check.
just for a moment.
No, you are right, but still it cannot be a ground of review. That you have to challenge.
Just for a moment, just for a moment. Page 118, man. Page 118.
And you did not appear when the writ petition was heard.
No, my lord, counsel appeared, but perhaps it's not properly assisted. I don't know.
No, nobody's.
No,
Nobody's.
shows. The order sheet shows.
No, it was only Mr. K. N. Chaudhary's junior and Gautam. Nobody's representing this review petitioner. Nobody's there.
No. The senior counsel Chaudhary appeared for all the private respondents. That's my instructions.
No,
I don't
no,
know.
Whatever.
Anyway, can we see page 118, madam? Just for a moment. In supersession of this department, earlier notification number so-and-so 8/2006, the governor of Assam is pleased to decide that the inter-C seniority of forest ranger appointed as per the merit list of APAC shall be fixed in order of preference indicated in the merit list of Assam Public Service Commission. Notification issue with approval of so-and-so. Neither by express words nor by necessary implication. This 11/2/2020 was given in a retrospective effect. On the face of it, madam.
So, Mr. Nath, what I'm telling you is that the expression private respondents used in paragraph 45, 14 of the order was obviously in the context of the submission made by the departmental council and was referring to those candidates who were appointed but were not part of the APSC list. Correct?
Madam.
So your client, though was a respondent, he was a part of the APSC list.
Madam.
Therefore, these observations will not be applicable to him. In para 14 and 15, the observations made would not be applicable to him. Whether he should get seniority or not, that aspect will not get into.
Because if, my lord,
because the direction is for the department to decide on the order of seniority.
Decide pursuant to mandate of 118 notification.
Correct. But that is wrong. According to you, that is wrong.
On the face of it, because
that you have to challenge the order. Nothing can be done.
There is no My lord, neither by express words,
Why don't you challenge the single judge's order?
nor by implication, my lord, on the face of it.
All right.
I know
You
my
can
limitation,
conclude.
my
You
lord.
can conclude now.
As a review,
You can conclude now.
as a review petition, my lord, I know my limitation. my lord.
That we have to also be conscious.
Yes,
Review is
yes.
very, very limited. If there is even what you are asking for is entirely a ground of appeal. But all right, you have been waiting for this matter. I'll give you that much. Beyond that, I'm not willing to give. I'm disclosing my mind. You can argue, but sorry. Beyond that is not possible. If the order is erroneous, possible.
No,
You have to challenge
not
it.
just erroneous, my lord, review when there is apparent error. When there is
We'll hear
apparent
it
error.
after Bihu then. It will take time. Because I'm not convinced that we can go so deep in a review petition.
No, on the face of
all
it,
right.
just bare reading of, my lord, this page 118 notification.
Continue. Argue. Argue.
No, but I'm just trying to persuade myself.
No, those things I'm not altering in the judgment. I'm making it clear to you. You may be correct that those are erroneous. All I'm saying is those things cannot be rectified in a review petition.
But I'm just trying to
No,
persuade
because
myself.
I'm not recalling this order and rehearing the writ petition. That I'm not.
No, not at all.
Without that, it cannot be gone into. These are the technical requirements which as judges we have to be conscious of.
My lord.
You can ask for it, but I'm telling you I will not give that order so that you can decide whether you want to argue here, spend your energy or try it somewhere else. I'm not even saying that you should not agitate these points.
No.
You want to
Yes,
agitate, you agitate.
That's
it.
my right, my lord. I will pursue.
You do it. But these things cannot be done without recalling the judgment and rehearing the writ petition. Your ground of review may have some basis, but these are not grounds on which the order will be recalled and writ petition will be reheard. Challenge that view of the court. That option you always have.
That option is always there, man.
You
Review
can have
application.
a genuine giver, but yes, these observations are all obviously directed towards those respondents who are not part of the APSC select list. But since you say that you are a part of the APSC select list, in 1 to 18, when the court examined it, your client's name was much below. This aspect was looked into, but the fact that he came in the list due to reservation, that was not pointed out. If that was
not
pointed out,
perhaps not
then the
pointed
matter
out.
would
Yes,
have been
yes.
different.
Perhaps
Is it
not
not?
pointed out.
So the court proceeded on the ground that your client's name could be in the list, APSC list, but it was below 18. And there it was for 18 vacancies. So below 18, no appointment could have been made. Therefore, it is not a part of the valid selection process. That was the basis on which the court proceeded against all the respondents, including your client. But now that you say that by applying the roster, he came within the 18 and was appointed. Therefore, it cannot be said that he was not a part of the APSC.
Because eventually, my lord, dispute was regarding emphasis seniority. Whether it should be on the basis of merit list of APSC or merit list of this training college.
Right.
That is the question, core question, madam. And this notification says it should be on the basis of APSC select list. I'm not challenging 118 per se, madam. I'm only saying that assigning retrospectivity in 118, that is my grievances. All I'm saying, madam, 118 nowhere stated, madam.
That's what I am saying is you cannot express a grievance in the review petition. You can only point out to the court an error apparent, a mistake committed by the court.
Exactly.
You have a grievance. That's what
Yes,
I am saying again and again. You cannot express a
I'm
grievance in a
just
review
trying to
petition.
persuade that whether this error of reading retrospectivity in 118 notification
What is 118?
apparent or not. This 11th of February 2020 notification. Because eventually direction
what is it? 118?
page 118 notification. That is dated 11th of February 2020. Because direction is to redraw seniority list, man, on the basis of this. Unless it is retrospective, man, it cannot apply to the batch of 1989-90.
Where is the direction to apply?
Yes. Para, my lord, 15, paragraph 15, my lord.
So have you challenged 111/2020? Mr. Nath, now see, I'll go into this matter, but it may affect your right to appeal also if it goes against. That is a risk you are taking. You have not challenged 11/2020 till today. 11/2020 notification, you have not challenged it till today.
No, no.
So I'll write a detailed judgment.
Perhaps we have challenged it. my
Where
lord.
is
I'm
it? In which writ petition?
Just, I'm referring.
You have challenged it? Your client?
Yes, yes.
In which writ petition?
Yes, yes, I'm just giving you the numbers. Well. That's it. My lord's order, page 27.
Page 27.
Huh. Page 27. WPC 4942, my lord. Here I am, petitioner number 2. Order, my lord, will find it page 29.
So it has been kept in abeyance. 11/2020 has been kept in abeyance.
Subsequently, by subsequent notification. By this impugn order, my lord, that notification was set aside. By which this 11/2020 notification was kept in abeyance. That notification, my lord, that is 7/11/2020, along with 8/2/2006 notification was set aside. Can you see?
Yes, correct.
Yes.
7/11/2020 had kept in abeyance 11/2/2020. So when it was kept in abeyance, the council submitted it at the moment there is nothing and the writ petition was closed.
Yes.
Subsequently, this issue was live in the other 4 writ petitions also.
Yes.
So the court has set aside and restored 11/2/2020.
Yes.
Correct.
Yes, yes.
So now 11/2/2020 is holding the field.
Yes.
Right.
And that's why my first submission is I'm not disputing 11/2 per se. I'm only on the fact that whether it is retrospective in operation. On the
That
face of it.
you raised that plea with the government. We are not here to give you all the
No,
answers.
on the face of it, my lord. That document is before my lord. On the plain reading of 11/2. Page 1.
Mr. Nath, you are asking these questions in a review petition. You know what is the scope of a review petition.
No,
Again
my-
and again
my
you are
submission is
asking.
this, my lord.
If we go deep into answering your questions,
My
then
lord, even divorce order 47. This court being a court of record has inherent power to correct an apparent error. Even though, my lord, this review application is barred by limitation. That's the law laid down by the Constitution Bench, my lord, in Sardar Begum. So we are not limited by this order 47, my lord. After all, this court has plenary jurisdiction. If I'm able to persuade myself, on the face of it, my lord, this 11/2/2020 notification has not given any retrospective operation by the executive themselves. That I'm just trying to persuade them.
all right.
There are a series of, my lord, notification issued one after another.
Where is that 11/11/2020? It is a part of the record.
Yes, yes, yes. That's I'm
Where is
referring
it?
to, my lord. Page 116, my lord. Sorry, page 118, Lord. Page 118. Can you read this notification, my lord? In supersession of this department's earlier notification issued by number so-and-so dated so-and-so, the governor of Assam is pleased to decide that the interstate seniority of forest rangers appointed as per the merit list of APAC shall be fixed in order of preference indicated in the merit list of the Assam Public Service Commission.
So what is the retrospective effect here?
Nothing, no. But my lord,
No, merit list of APSC is that list, original
Not
list?
just APSC list, every appointment
Oh,
to rangers.
please talk about this notification. It
Huh?
refers to as per the merit in the APSC list. Which is that APSC list? Dated?
No, it is not just one particular, it is not just confined to 1989-90 batch, my lord.
Oh, in your case, which is the APSC list here?
In my case, the APSC list is this, my lord. Page,
Page 63.
no, page, my lord, the 61. Page 61, my lord.
Yes.
All I'm trying to articulate, my lord, this notification, 11th of February, is not a case-specific notification, batch-specific notification. It's a general notification laying down the seniority criteria for fixing interstate seniority of
So
forest
what do you want? What is the change? What is the other change you want in the judgment? What is that which is troubling you?
Consequential seniority, to give to the petitioners in the promotional post. My lord, I was promoted to DCF long back.
No, there is a direction to give consequential seniority.
Yes.
Where is the direction?
Page 140, my lord. Oh, sorry. Page 141.
Please read out what is the direction.
Para 15, my lord. 141. Taking note of the submission of the learned counsel for the parties as well as the stand of the learned departmental counsel and agreed by them, these writ petitions are being disposed of by directing the department authorities to fix the interstate seniority of forest ranger of 1989-90 batch by following the mandate of OM dated 11/2/2020 as reaffirmed by the OM dated so-and-so, and thereafter publish the final gradation list of forest rangers for the relevant period. Based on the final gradation list, consequential seniority and other service benefits to be given to the writ petitioners in the promotional post. The department shall also consider the claim of the petitioners for promotion to the rank of DCF, DFO, by taking into account their seniority position in the feeder cadre.
So what is wrong with this?
Madam, this direction was given reading retrospectivity in 11/2/2020.
Where is that finding?
It says that fix the seniority position of 89-90 batch by following 11/2/2020 notification. That cannot be done unless it is retrospective in operation. How can it be done, madam? Fixing interstate senior 1989-90 batch by notification issued on 11/2/2020 unless it is retrospective in operation.
And 11 to 2020 only says they will follow the APSC merit list. How is it going against you? You are quite high in the APSC merit list.
What the direction? My lord says.
So how are you affected with this? Tell me that. If supposing what the court says, supposing that remains, you are going to get accelerated seniority because your name is pretty high up in the APSC list.
My lord, no. My name is lower than them in the APSC select list.
Lower than them means?
Lower the writ petitioners. So 11/2 if followed, then they will still a march over me.
And if it is not followed, then you will become senior to.
Yes.
How is that?
If it is followed, if this gradation list of rank list of training college followed, I'll be senior because I ranked second there.
Challenge this order. That's what we are saying. This court has taken a conscious decision not to allow that. Challenge it. Why are you in a review? Again and again, I'm saying that if you have disagreement with that,
That
challenge
tree
the
is
order.
always open, man.
Then
I'm just trying
it
to.
cannot be done in a
Probably
review.
that there is
That's the
an apparent.
view of the court, will not change it. Reviews are not to be used for these reasons. Long drawn arguments. You are aware there are so many judgments that in the
absolutely.
garb of review, rehearing, going into lengthy arguments, these are not
So
permissible.
I'm just praying that read 11/2/2020 notification. Just read it and whether there is any retrospective operation given there. No argument required, my lord.
No retrospective appointment is given.
Then the
But
matter
we'll- we'll not-
the direction shows, my lord, that fixed interstate seniority of 89-90 batch by following 2020 notification.
All right. What else? You want that clarification that the reference to respondents in para 14 means those candidates who were appointed not based on the APSC. Is that what you?
No,
is
that
that going
will
to
not
help you?
materially change my position. That's my submission.
No, that I'm not going to change. I'm giving you my verdict. Even if you argue for next few days, I'm not going to change that. You decide what you want to do. But if you want a detailed order, I'll pass it. But then I'm not sure whether it will be good for your clients. Mr. Nath?
I know my limitation. my lord.
No, it's all right. We are all doing our job.
Yes,
But,
exactly.
Why don't you prefer a writ appeal by withdrawing this petition? Because you see, any observation from the court at this stage, you may have a point. Test it before the appropriate forum.
My predicament
coming
is
to the
that
same
my lord, I
court
came very late
Huh?
in this matter.
Hmm?
My predicament is that I came very late in this matter.
You came late, but your clients came to you
Exactly.
in the right time. Say that. They are lucky that they have met you in the right time. But question is, at the end of the day, entertaining all these arguments would amount to rehearing of the writ petition, which is not permissible, and this court will not do it. This has been the consistent stand of this court. If you see many other judgments
No,
where
no
this has
dispute.
been, if there is a
dispute.
that can be looked into. For example, the court proceeded on the view that all those forest rangers appointed in that time, whose names are not a part of the APSC select list, in the light of Department Council's submission, it was observed that they did not come in through a legitimate process, and therefore their seniority claim cannot be recognized. That is a view expressed by the court.
Yes.
But your client was not a part of that. So that clarification, that is a mistake. That we
So
can
far,
give.
no problem.
But to say that this 11(2) cannot be applied, doing it with amount to retrospective effect, that is an error of the court's view, if at all. That you have to get it corrected in the appellate forum. How can the review court agree?
No.
The review court
It
cannot
appears that
entertain
I've not
it.
been able to persuade myself that it's an apparent error.
It's
My
a
lord,
wrong judgment, I'm telling you. This
I
judgment is wrong. But still, in the review petition, it cannot be corrected. Does it make you happy?
I go down to your lordship. I go down
15,
to your
para 15 is erroneous.
I go down to your lordship.
But I, as the same judge, cannot set it aside.
I know my limitation in the review petition.
If you know your limitation, you have to understand the limitation of the court also.
I'm just, my lord, doing my best. to
Cannot be
persuade
done,
my lord.
cannot be done. See, your point, I have taken it in first 5 minutes. Only thing I am trying to convince you is that this is not the forum to argue these things. I don't know why you are reluctant to go to the appellate court. I don't know. Is there any reason for the reluctance?
No, my lord, I'm not directly in this matter, my lord, so.
No.
I mean,
That
so
is
I
another
have
matter.
no direct contact with the client, my lord, I have no answer to that. Why it is not filed or now what he's thinking, my lord. I'm just engaged for this matter later on, so I'm just trying to do my best. That is it.
You want to argue further?
No, but if that is.
No, that is the law. That will not deviate. Because I understand your point. If I had not understood, then I would have heard you for another 2 hours. I know what you are hitting at. As simple as that. You are saying this judgment has revived 11/2/2020, which is a notification which came in much later than when we were recruited. So by following this notification, how are you going to fix our seniority, which will date back to 89. That's your argument. So therefore, it is an erroneous finding. Suppose you think rationally, if your argument is to be accepted, then the court will have to recall the order, revive the writ petitions, rehear the writ petition. Correct. To do that, I do not agree that it's an error.
That's
It's
a
an
view.
error. I don't know. It is your interpretation,
I go down to your
understanding of
lordship.
this
That's the
argument.
view of the court. I go down to your
Yes.
lordship.
So one view of the court which is plausible, that cannot be a ground to.
I'm just trying to show perhaps it's an apparent error according to
No,
me.
no, it is not
I've
an
not been
apparent
able to persuade my
No,
lord.
not an apparent error. No, no, you have it tested. You tell your client to have it tested. They may succeed, he may succeed, I cannot say, but it's not an error.
That's
This is the understanding of law by the court and deliberately the order has been passed. Please don't think it is an error. No, no, nothing. It's a deliberate order and that's the correct view according to the court. Have it tested if you don't agree. As simple as that. All right, had anything else you want to say? I think that's all.
That's all. Lordship, my colleague.
We'll give that clarification. That clarification will
Yes.
Only one sentence was missing, my lord, then I'll add, my lord, the apparent face on the face of record. Record says that 18. He's only original 18, and that is, I give him. I was not referring to him as an outsider beyond 18.
Correct.
And for that, lordship has to go to page number
I don't
49.
understand why was he a respondent if he is a part of the
Yes.
18?
And page 49, my lord, will see the original advertisement. It was called for, its application was invited for 18. And he was a part of 18. Roster or no roster, that's a different issue, but he was a part of the 18, original 18. But he joined when he assailed the notification, he joined the other persons who were beyond the 18.
When he joined
when he assailed the notification, he joined the other persons who were not beyond the 18. He was a group of, he joined the group of the persons who were beyond 18.
That's where the problem started for your client.
That's the confusion.
You joined the wrong group.
That's the confusion.
He should not have been a respondent in the first place.
Because the writ petition is filed by the respondent here, private respondent
Correct.
here. We made respondent because the allegation are made that we are not properly recruited.
No, that was not the allegation.
No, can you see this order? Can you see the writ petition? Can you see the submission? Order will reflect that. Can you see this order? No. Can you see this order?
When the petition was taken up, this issue came to light when you
Can
entered.
you see the interim order? Your statement was recorded, na?
Anything which is out. It's
Please see your submission was recorded in the interim order.
That day you were not there.
Mr. Nath, the crux of the matter is that the whole problem has happened because your client took longer than necessary to reach you. Now that he has reached you, now I think things will fall in line. Rest of it is mere details. But you have two petitioners or one petitioner here in the review petition?
One petition.
Only one.
One.
Lordship permits me to make 1 minute, one small.
Then I'll allow it.
No, just.
You are for response number 9.
Yes.
And you are for one, who's for 8?
Yes, the private respondents.
8 and 9. And you are for 1 to 6.
Well, it's
1 to 6. One is appeared for APSC.
My senior friend had it. I think he's on break as of now.
Who is?
He the problem.
What do you want to say? What do you want to say?
It doesn't come.
Please understand.
No.
No, what do you want to say? Let's see. What do you want to say?
Page the 14th paragraph, the 15th paragraph. The Lordship talks about fixing the APSC merit test as per the OM dated 11/2/2020. That order was occasioned because 2 outsiders were promoted superseding us. Now, if my promotion dates back to their date of promotion, the review petitioner's client also was not promoted at that point of time. So even his promotion will be accelerated to 2012. That is my submission. That will help him.
That is his cause of action.
That is
now that this submission he'll use in writ appellate forum or a writ petition.
Yes.
But how does it help in the disposal of the review petition? Doesn't help. Is it not? Anyway. Sorry? All right. I take down, heard Mr. and Learned Counsel, assisted by Mr. Huh? R. Karin, Learned Counsel for the review petitioner. I have also heard Mr. D. Gogoi, Learned Standing Counsel, Environment and Forest Department, Assam, appearing for the respond numbers 1, 2,
1, 2, 4, 5, 6.
and
One.
6, Mr. Sikias Borua, Learned Government Advocate, Assam, appearing for the respondent number 3, and Mr. P.P. Datta, Learned Standing Counsel, APSC for respondent number 7, full stop. Mr. M. Datta, M. Sharma, Learned Counsel is present for the respondent numbers 8 to
8 and 9.
Huh?
8 and 9.
8 and 9.
Yes.
8 and 9. What about 10 to 12?
10 to
12 retired.
Achha, nobody has appeared here.
Respondents in the petition.
All right. Take down. By filing this review petition, the sole petitioner is seeking review of the judgment and order dated 9/4/2024 passed by this court disposing of as many as 4 writ petitions, namely WPC number 6723/2013, WPC number 4294 of 2020, also WPC number 1148 of 2021, and WPC number 4948 of 2020. Full stop. It will be pertinent to note herein that the review petitioner was the respondent number 9 in WPC number 4948 of 2020 and the respondent number 10 in WPC number 1148 of 2021, which was instituted by the private respondents in the review petition. Full stop. The core controversy involved in this in the writ petitions were pertaining to the claim of fixation of seniority of 2 batches of forest rangers, two batches of officers who were initially engaged as forest rangers in the year 1989. Full stop. On 20th to 1989, the Assam Public Service Commission bracket APSC bracket close had invited applications for engagement in respect of 18 stipendary studentship for the year 1989-91 in the Rangers course, COURSE, in forestry for the State Forest Department, Soil Conservation Department and District Council, which was to be held in the Eastern Forest Rangers College at Korsiong. Full stop. Upon completion of the selection process, the APSC had forwarded a list of selected candidates containing 44 names in total. Full stop. The private respondents were amongst the selected candidates as per the process conducted by the APSC, as their names did find place in the select list dated select list dated 20th of June 1989. Full stop. After the selected candidates had completed their training course, they were all engaged as forest rangers. However, around that time, some other candidates who did not take part in the process conducted by the APSC for engagement against the 18 stipendiary studentship were also engaged. Full stop. Those candidates were also subjected to training course in the Forest College and thereafter were appointed as forest rangers. Full stop. It is in such context a dispute arose as to whether the candidates whose names appeared in the select list prepared by the APSC and were within the 18 candidates who could have been appointed by operating the APSC list dated 26/1918 can be treated as junior to those forest rangers who were appointed dehors the APSC select list merely because such candidates had scored higher marks and were of better ranking in order of merit in the training course conducted by the Forest College.
The others also APSC selecting, my lord. Their name also appeared amongst his first 44, but not within 18. Not within 18.
In other words, the candidates whose names did not come within the 18 candidates who could have been appointed as by the APSC select list dated 26/1989 were also appointed as forest rangers, but their seniority was assigned above those candidates appointed as forest rangers whose name appeared within the 18 shortlisted candidates as per the select list dated 26/89 by taking note of merit position of the candidates during the training course held at the Forest Rangers College. Full stop. Thereafter, several notifications were issued by the government of Assam with a view to deal with the issue of fixation of the seniority, inter-se seniority of forest rangers for the purpose of considering their cases for further promotion. Full stop. Since the private respondents were not within the 18 candidates in order of merit furnished by the APSC wide list dated 26/1989, and considering the fact that only 18 vacant posts of stipendary studentship was advertised by the APSC. Hence, a projection was made that the private respondents were not appointed pursuant to a valid selection process, and therefore their seniority cannot be recognized above the writ petitioners who were part of the 18 candidates in order of merit as per the notification dated 26/1989, which contained the name of 44 candidates. Full stop. Taking note of submissions of learned counsel for both the sides, this court had disposed of all the four writ petitions by making the following observations in paragraph 14 and 15, which are reproduced herein below. Page 140 or 141 of us. Mr. Nath, learned counsel for the review petitioner, has submitted that although the name of his client figured at serial number 31 of the
13 minus 1-3.
no, in the original list, 20th of
Original
June,
is 31 minus.
31 in the list dated 20/06/1989, published by the APSC. Yet, after operation of the reservation roster, his overall ranking went up to serial number 13, and accordingly, the review petitioner was appointed. Full stop. Therefore, it is not the case that the review petitioner was not amongst the 18 candidates appointed by operating the APSC list dated 26/1918. Full stop. However, since the review petitioner was respondent in 2 of the writ petitions, and on account of the fact that aforesaid factual position was not pointed out at the time of hearing of the writ petitions, an error apparent on the face of the record has crept in, whereby this court had categorized the review petitioner also amongst those respondents those respondents who did not feature in the 18 candidates appointed as per the APSC select list dated 20/06/1989. Full stop. By referring to the observations made in paragraph 15, Mr. Nath has further argued that by restoring the notification government OM dated 11/2/2020, this court had permitted the authorities to fix the seniority of forest rangers by retrospective application of the notification to the forest rangers of 1989-91 batch, which was impermissible in the eyes of law. Therefore, an error apparent on the face of the record has crept in the judgment and order dated so-and-so on such count as well. Full stop. Mr. Gogoi, learned standing counsel for the Forest Department, has submitted in his usual fairness that the review petitioner was placed at serial number 13 in order of merit after operation of the reservation roster, and therefore it is correct that he was in equal footing with the writ petitioners who had claimed their right on the basis of their selection as per the APSC select list dated 26/1989. Full stop. To that extent, Mr. Gogoi has accepted that there is an error apparent on the face of the record which calls for rectification. However, as regards the revival of the OM dated 11/2/2020, which lays down the criteria for fixation of seniority amongst the forest rangers, Mr. Gogoi submits that there is no illegality in the views and observations made by the court in paragraph 15. Mr. M. Sharma, learned counsel for the private respondent numbers 8 and 9, submits that save and accept the clarification in respect of the point that the review petitioner was amongst the 18 candidates appointed by operating the APSC select list dated 20th of June 1989. No other error is apparent on the face of the record of this case. First up, I have considered the submissions made at the bar and have also gone through the materials on record. After a careful scrutiny of the materials brought on record, it appears that the review petitioner herein was ranked at serial number 13 in the, and as per the select list prepared by the APSC by operating the reservation roster, and therefore his appointment as forest ranger was obviously based on the APSC select list. However, since the review petitioner was impleaded as a respondent in 2 of the writ petitions, and such facts were not pointed out to the court, hence an error apparent on the face of the record has occurred in the order dated so and so, whereby it was projected that it was whereby a projection was made that the review petitioner was not one of the duly selected candidates as per the APSC selection process. Full stop. However, insofar as the submission made by Mr. Nag questioning the observations made in para 15, after a careful analysis of his arguments, this court is of the opinion that by advancing such arguments, the petitioner is seeking a rehearing of the writ petition on merit, which is not permissible in a review petition. Full stop. If the petitioner is in any manner, review petitioner is in any manner aggrieved by the findings and observations made in para 15 of the judgment and order dated so and so, the remedy would lie in preferring an appeal, but not seeking a rehearing in a review petition. Rehearing of the writ petitions by filing a review petition. Full stop. Law is firmly settled that issues which call for long and elaborate hearing cannot be treated as error apparent on the face of the record, which can be rectified in a review petition. For the reasons stated here and above, these review petitions can be disposed of by clarifying that the reference made to the private respondents in para 14 and in other parts of the judgment shall not include the writ petitioner, since he was a part of the duly selected 18 candidates as per the APSC select list dated 1989. With the above observation, the review petition stands disposed of. So you take your chance. You have tried, but you have given the answer. All right.
Much obliged.